Seven.
We're back. Good morning, everybody. Happy Thursday. Welcome to the Courtroom Files Live. No tech issue will keep this show down for long. Apologies for yesterday, but we are back. We're going to start the day in the Wayback Machine. This is our good friend, Horterman.
No, thank you.
You waive your right to a lawyer?
Yes, sir.
Please tell me that there's been substantial progress on the property. I'm talking to the prosecutor.
I would define it substantial, Your Honor. I did have the department, somebody took photos from the street on Thursday. It shows the boat, the amount of the vehicle, the trailers. He got a large delivery of wood that is now in front of the property. There's junk along the side. I do have those photos if you want to take a look at it. I do see that the trailer in the back of the property is full. Mr. Boyd did say that it was full. It just needs to be cycled out and he needs to keep working on it. He also has not obtained a demolition permit yet for that dangerous building back in the back.
I don't know what to do with you.
I don't know how long it's good for, so I'm waiting and, I can't get the trailer out because the guy went up deer hunting and then he's up north with his boss working on.
Whose trailer is that?
Cabin.
Whose trailer is
So he's coming
that?
back.
Whose trailer is that?
The dumpster.
Yeah.
Wait a minute. So it's being used as a dumpster, the trailer is?
The trailer is a dumpster.
Okay.
That dumpster, you can see in some of the photos.
Yes.
That is full. There's still all the trailers being used as storage essentially though on the property.
What are you doing with the boat?
Trying to sell it. Got his for sale sign on, got it up by the road.
How long you had that up for sale?
Well, it's the middle of winter and
No, I didn't ask you that. I just want to know, can I have
Oh.
another page, second page to a register of actions?
since,
I think it's been about September or October, you know.
All right, talk to me, not to her.
No,
I'm just-
it's in November when we put it out.
I mean, it does look a little better. I'll give you that. But you still got to get the boat out and you got to get the garage torn down.
I've had the flu since Christmas.
What's in the trailer?
I believe that Mr. Boyd has taken property out of the garage and that's what's in the dumpster.
Well, no, but there's a trailer. Is this not a trailer? This black, it looks like a black trailer. Then.
Yeah, there's about 2 or 3 trailers on the property. They're just full of, excuse my language, junk. So those need to go. You can't use storage like that on the property.
When are you going to get rid of the junk in the trailer?
A lot of it isn't junk.
What's in the trailer?
Tools. I gotta put my, rototiller in there. My lawnmower in there.
Tools,
Yeah.
lawnmower?
Yeah.
What else? Is it filled up?
No,
What else do you have in the trailer?
no, I got some kitchen cabinets that I gotta put up
You're going to put them where?
Huh?
Where are you going to put them?
in the kitchen.
How long have you had the cabinets in the trailer?
November, December,
Where'd you get the cabinets?
my daughter. She,
What?
remodeled her kitchen. And, they're all handmade cabinets. They were too dark. 2 months white.
Who's gonna take the dumpster out of there and take it to the dump?
The man who owned it. I rented it. $400 a shot.
Is it filled up yet?
Yeah, it's good.
When's he coming? When's he gonna come get that?
I'm gonna call him today, see if he's back in town.
What about the other inoperable vehicles?
The inoperable vehicle, got a broken shock. I gotta put it into
Is that, these are the same vehicles been sitting out there?
They are, Your Honor. See with the trailers, those have all been there since we did this,
I don't know what you're gonna make me do, Mr. Boyd. I really, Mr. Boyd, come on.
I gotta work on the garage, getting it in. Everything else is secondary.
Well, that's your opinion. That's not my opinion.
We do one thing like that at a time.
Mr. Boyd.
Top.
Mr. Boyd, I'm gonna let the prosecutor remind you how long they've been dealing with this, with your property.
Your Honor, I believe these citations date back to 2001.
So it's only been 25 years,
I didn't know about it.
Mr. Boyd. I don't know why you're not good. I don't know why you're just insisting that I send you to jail. I don't understand it.
I can't do anything, you know.
Mr. Boyd, you're not doing anything out of jail either.
Can't do anything. till-
Mr. Boyd, this has been 25 years. 25 years, sir. I was young. I'd like to go back 25 years. This is my early 40s, 25 years ago.
Nobody come and talk to me. Except for, the guy that retired,
What year did he come and talk to you?
just before Rob took over.
What year was that?
Last year, 25.
So you're saying you didn't know anything about this until 24? The township hasn't been bothering you to get this junkyard picked up, sir?
Well, he just coming.
Sir, I'm asking you when your first notice was from the township that you had a blight condition, they wanted things out of there.
Nobody called it a blight condition.
Sir, when did you hear from this township in reference to the condition of your property?
Probably 24.
So you guys are off by 23 years. She thinks it was 01, you think it was 24. That's one big difference. Now, I hear a lot of opposite stories here. Some people call it one, some people call it a million. I hear different stories, but that's quite a disparity. That's 23 years, not 23 days, not 23
That's
weeks.
when I got the letter in the mail. 24.
Would you look on the computer, please, for me? Can you pull up Mr. Boyd's name, please? I like you. I do,
I like you.
but I have a job.
So do I. I gotta get that.
And you're not following orders of the court.
Nothing I could do with being sick.
Mr. Boyd, you've given me every excuse under the sun.
No, it's a bad flu.
Well, let me see here. I see Robert Thomas Boyd. Allow inoperable vehicles, 2002. Improper storage, 2003. There's other ones that were set aside under a statute, building code violation 24. So they were dating back to 02. I don't know why they let it go from 03 to 24, if that's what they did. But you've had since April of 25 to get rid of this stuff. And I don't know what to do with you other than just lock you up.
I think if it was,
Mr. Boyd,
2002.
Mr. Boyd, I've had every excuse under the sun from you. I don't know how many times you've been in front of me on this case. I have had every excuse under the sun. You're sick, your boys won't help, they're too busy, you don't have the money, you gotta go to work, it's too warm, it's too cold, it's too this, it's too that. And here I am trying not to send you to jail and knowing when I don't send you to jail that I'm not handling my office appropriately. You know that? That's what I'm doing. I'm not handling, I'm just not following what I should do and what I do. So basically, somehow, some way, I've treated you better than I treat anybody else.
I appreciate it.
Well, no, but I don't want to treat you better. I feel sorry for you. I'm trying to help you. I'm trying to reason with you, and you're not taking any reason.
But if
You're just not going to listen to judges. You just don't. I don't know if you think I'm kidding up here.
I'm working on it. I've got 2 trailers full of junk out of there already. 2 dump trailers. They're big.
You got to get the garage done. You got to get the trailers out of there, the dumpsters. You got to get the junk out of the trailer. You got to make sure that your vehicles are operable, not inoperable. Are
Yeah,
they properly plated? No, they're not properly plated either, are they?
yes, they are. And they're insured.
Why did the township wait so long? If they were dealing with this in 02 and 3, what took them 21 years to start?
It wasn't
Hang on.
anything like that.
Hang on, and let me talk to her. I was talking to her. I wasn't talking to you. Why did they wait so long?
Jerry, I do know that we've issued municipal civil infractions that are handled through the township, along with multiple notices.
Are you gonna deny that too?
What?
She just told me that multiple municipal civil infractions, which would not have been filed here, were issued to you many times between 03 and 24. Is that true or is that false?
I had.
True or false? Just give me a straight answer, please. I don't want to have to be a dentist today. I just don't. Is that true or false?
Well, it's not that simple.
Did they send you municipal civil infractions or not? It is simple. What's hard about that? It's either yes or it's no.
In 2003, I had 2 cars in my yard.
Mr. Boyd, I'm just asking you a simple question. Between 2003 and 2024, did this township send you municipal civil infraction violations or did they not? In other words, is she lying to me? Is she lying to me?
I wouldn't think so,
Okay, so she did, so they did send you notices, right?
but I have.
Right?
People.
Right or not? Please tell me if I'm right. I'm gonna get agitated if you keep playing with me. Did they send them to you or not?
I don't know.
You don't know?
My ex-wife picked up the mail.
Oh my gosh. You know what I want to do to that? That's what I want to do to that. That's ridiculous.
She didn't like me too much.
Boyd, you got 2 months to get everything taken care of. I'm going to give you one last chance. This is not a threat. This is a promise. I'm going to adjourn the review hearing. You've got to get, you got to do this. This is not a request. This is not a suggestion. I'm not asking you anymore. I'm telling you, this is what you're going to do. Do we understand one another?
Yes, ma'am.
The last thing I want to do is put you in jail. But I'm going to do it if you don't have the property cleaned up like I told you multiple times. Give me a date in the end of March, Heather.
We could do March 25th, Judge.
March 25th at 8:30 in the morning. You want to take your, did you have something to say?
Just briefly, I did want to remind Mr. Boyd, I know we talked about it a little bit, is that there's a Good Samaritan with a team of people that want to volunteer to help him clean his property. It's my understanding that he says that he doesn't need her yet, that he had one person before, but I think that this is a much larger problem.
They'll help you.
Yes, sir.
If you,
I have to have somewhere to put it. The trailer in my yard, the dump trailer is full. That guy's been away for 6 weeks.
Well, tell them to come and get it.
I did.
Listen to me.
He's calling me.
Take the help that the township's offering you. There's going to be no excuses next time. You understand? You do what you got to do, but I'm telling you right now, you've been in front of me on a multitude of occasions on this case, and I'm telling you, if you don't have that property cleaned up to my satisfaction in a compliance with the orders that I issued previously, I'm giving you the other remaining days, whatever they are. Do you understand me?
Yes, sir.
Take your photographs back, please. You can keep these and you can mark down what day they were taken so you can bring them next time and have updated photos. Thank you very much. Go down the hall, get your notice, sir. Good luck. I'm telling you, I'm not going to do this again. Marcus Liddell Allen.
Good morning once again, everybody. It's TCF Live on a Thursday. Welcome. Good to have you all here. Barbara, thank you for the $5 super chat. Thank you for the gifted membership. Wahoo, thank you for gifting a membership in real time here. Appreciate that. That was the Wayback Machine. That was Hoarderman from yesterday when unfortunately we weren't able to be online because of tech issues, which we appear to have solved, which is just super duper great because I hate missing days with you guys. So I have deep thoughts on this whole Hoarderman situation, and I would like your thoughts as well, but we're going to save it for the 4th hour. So when we get to TCF overtime, one of the things we'll talk about is Hoarderman. So let's get out of the Wayback Machine and back into today's action. Let's go to Georgia. This is Judge Lal.
Also,
And position 45, it just got duplicated on the calendar. It's the same as 44.
Okay, so I'm just going to cross out position 45. All right. So Darius Parks has got 2 matters before the court. It is case 26 CR 031D, in which he is accused of criminal trespass, public drunk, and a PI charge. And he's got a second case, 25 CR 6861D, for criminal trespass. The first case is from a January 1st, 2026 incident. The second case is from a January 2nd, 2026 incident. Mr. Parks, you've been advised of your rights, and your attorney is Ms. Tucker. Ms. Tucker, is this going to be well, how are we going to proceed?
It'll be a negotiated plea, Your Honor.
All right, thank you. Mr. Parks, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? I can't hear you. Was that a yes or no?
Yeah.
All right, you'll need to speak up. I think the mic may be a little further away from you. Okay, Mr. Scirocco, what is the recommendation for both these cases?
Yes, Your Honor. For position 43 on criminal trespass, public drunk, and the PI, which are counts 1 through 3 respectively. On count 1, 12 months probation concurrent with count 3. Stay away from all MARTA premises and property. Count 2, 12 months probation concurrent with count 3, ADET. Count 3, 12 months, served 28 days, credit for time served, balance probated, SDET, as well as 60 hours community service. And as for position 44, the criminal trespass, 12 months probation concurrent with position 43. Stay away from Azalea Fresh Market at 25 Peachtree Street, Northwest in Atlanta. We would ask that defense stipulate the factual basis, venue, and ID for purposes of the plea. That is all for the state. We are fine with non-reporting upon completion of the terms.
Your Honor, we do so stipulate for the purpose of the plea, and we would also request non-reporting once he completes all the terms.
Oh, let me see. I have a pretrial officer on Zoom, please. Ms. Stallworth?
Yes, Your Honor. Give me just one moment. I'm sorry.
No problem. I just wanted to know how many cycles Mr. Darius Parks has. I see that other than these 2 cases, his last booking at Fulton County was 2014. Does he have any other matters in other jurisdictions?
There are 16 cycles in total. As far as convictions, there's a to 2010 out of Fulton. You just want to know out of Fulton?
Okay. Does he have any probation matters recently in the last 5 years?
No, no, Your Honor.
Okay.
Not in the last
Yeah.
5 years, though.
Okay. Yes, Ms. Tucker, I will accept non-reporting once he has completed all the programs that he's required to do and his probation fees are up to date and he hasn't been arrested while on probation.
Thank you, Your Honor.
Okay. Mr. Parks, have you consumed any medicine or alcohol recently?
No, no.
And have you understood what's going on in both your cases?
Yes,
And are you satisfied with your attorney?
yes,
And has your attorney explained to you that if you plead guilty to these charges, you'll be required to report to probation every month and complete the conditions that are required?
yes,
All right. And has she also explained that if you enter this plea, you would have, can you hear me all right?
yes,
Okay. If you enter this plea, you would have to give up your right to a trial in a court of law. You will not be able to go back to face a judge or a jury with respect to these cases. You won't be able to confront your accuser, challenge the evidence brought against you, present your defenses and arguments, and the state won't have to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
yes,
Are you prepared to give up these rights?
yes,
How do you plead to criminal trespass at the Azalea Fresh Market on October 31st, 2025?
guilty,
How do you plead to criminal trespass, public drunk, and a PI charge from a January 1st, 2026 incident?
guilty,
For position 43, count 1, criminal trespass, the sentence is going to be 12 months to serve 28 days, credit for time served 14 days, to stay away from all motor property in accordance with any and all active suspensions. That includes the stations, the buses, and the trains. For the public drunk charge, that's going to be 12 months concurrent with count 3, and he'll be required to undergo an alcohol and drug evaluation and submit to any treatment that's required. And this must be done within the first 30 days of being released. With regards to the PI charge, it's going to be 12 months to serve 28 days, credit for time served 14 days, balance probated. He will report to probation on Monday before 3 p.m. And within 90 days of being on probation, he will enroll in an SD program and submit to all evaluation and treatment that's required. He will also complete 60 hours of voluntary community service at any nonprofit agency, and it cannot be a church and it cannot be a school. And he must complete his community service at a minimum rate of 10 hours per month, beginning with the first month. With regards to the second case, this will be a concurrent sentence, and it's 12 months to serve 28 days, credit for time served 14 days, to stay 200 yards away from the Azalea Fresh Market at 25 Peachtree Street in Northwest Atlanta. He will report to probation every month, be current with his probation fees, and once he has completed all the programs, the community service, and he has not committed any violations of probation and is current with his probation fees, then and only then will his probation be non-reporting. Thank you.
Thank you.
Before we proceed to the next matter, could I just inquire?
All right, friends, good morning once again. TCF Live on a Thursday. Thank you all for being here. If you are new to the channel, do please say hi in the chat. This is one of the best communities out there, really in any sector of YouTube, in my opinion. So engage them. They'll love you back. Tonight, Sidebar, 8 p.m. Eastern, 5 p.m. Pacific. You need to join us for Sidebar. And the reason why is that the viewers are in control tonight. You tell us in the chat what you want us to talk about, and that's what we will be talking about. So be super cool. Again, that's 8 Eastern, 5 Pacific right here on this channel. Do join us. Let's we're going to go back to Judge McNally, but this time in real time, not in the Wayback Machine. This is what's currently going on.
guilty plea, $500 personal bond. You're gonna go sign in out there. He's gonna take this file to the prosecutor. Prosecutor will come get you. They'll talk to you. Bond conditions, if we don't resolve it today or otherwise, you cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. Do you understand all that?
Yes, sir.
Any questions?
No, sir.
All right, good luck to you. People against,
Thank you.
and either way, you're coming back in front of me. Daniel Curtis Giles here. 25T646053A and B. I'm gonna need the prosecutor on this. 249. Can you come on in here, please?
Absolutely.
Thank you. All right. Good morning. Your appearance?
Tim Gambler, P78192, on behalf of Mr. Giles is also present.
Sir, your name?
David Giles.
So I need to set this for trial. I made myself a note if it didn't resolve last time. So we've had 1, 2, 3 pre-trials. This is see, we had one November 20, December 8, January 15. So I got to set it for trial. So
This is only my.
I'm setting it for trial. I'll give you,
I understand, Your Honor. I just want to make sure that there are some still,
Mr. Bologna, your name?
Anthony Blanchard. Okay.
What, there's still what?
there's still some discovery issues that I need to issue some subpoenas for hospital records, try to find the identity of security guards, and see if there's any video from within the hospital. So I would just ask the court that I appreciate the fact that we're going to set a trial date. If we could set a pre-trial date. or a
I
trial
will do
date.
that before that. You want a jury trial?
Yes, sir.
Okay, we're gonna set a jury trial at the end of February, Heather.
Okay, I think we just did one yesterday, Judge, on the 20th.
Who's that with again?
That one was that Carrie Moran.
That what?
Carrie Moran, she was that case from 2016. She zoomed in yesterday.
I'm gonna set this one for that date too, February the 20th at 8:30. I'm gonna need the jury instructions and I'm gonna need you to fill everything out. Like I just have to read them, Mr. Bologna, okay?
Understood here.
So jury instructions due by January 16th. We'll set a final, I'm sorry, by February 16th. We'll start promptly at 8:30 on February 20, and I'll give them a final pretrial date on the first February docket.
Okay, that will be February 12th.
That's a little late, isn't it? I don't want to go that late. We don't want to have to send out notices.
Or
if-
we have Trenton on the 29th of January.
January 29th at 8:30.
That's the final pre-trial.
Final pretrial will be January 8th. I'm sorry, give me 1 second. Jury trial will be February 20 at 8:30. Final pretrial will be January 29th at 8:30. Jury instructions due February the 16th at 8:30.
Your Honor, the only concern I have with that schedule is that it's 2 weeks, gonna be enough time for me to subpoena documents and subpoena individuals' identities. This is stuff that should have been in a police report. You know, they mention witnesses, but there's no names for them. I've got to go track that down.
Well, I don't know what, I gotta move this case. I mean,
I understand that. I'm just saying, I just would like, if I could get the pre-trial date, I mean, it seems like.
I'm not setting a jury trial date and having them send out notices to the public and then having them take off work and cancel vacations or will get babysitters only to have the case settled. To me, if it doesn't settle on January 29th, we're gonna go. I mean, I don't know what to tell you. I arraigned him on November 6th.
Right, and I was on this case in.
December 8th. December 8th, you were on the case,
November 8th, so
I believe. I think that's what I saw.
that seems legitimate. Again, my concern is subpoenaing. I'm gonna
Subpoena.
subpoenas today.
Well, I don't know do you know what he's talking about, Mr. Bologna?
I believe there's unidentified persons that work at the hospital that he wants to figure out who they are in the police report.
Did this incident occur at the hospital?
There you go.
Well, you got, what else to tell you? I'm not gonna adjourn it again.
Can we go one more week on the
I
pre-trial?
only have Trenton every other week.
So there's nothing first week of February for pre-trial?
I don't have it. I have Trenton every other week. I mean,
And Your Honor, I can see what I can do. I mean, I don't know how long it's gonna take them to respond to a subpoena. That's all, all I can do is,
why don't you subpoena him to the courthouse on January 29th, the records keeper? Feel free. And then Mr. Bologna will have an opportunity to get the records as well.
what time is the pre-trial?
8:30. Okay. Have a good day, gentlemen. Thank you. Aaron Arthur Lenz, 25G306-815. Good morning, Mr. Lenz. I mean, I don't have another date, right, Heather, after the 29th, right?
Correct, Judge. It's that one that was too close to the jury date.
All right, your name, sir?
Aaron.
You met with the department rep and you're going to plead to impeding traffic, true? Yeah, I gotta send this to him, back to Gibraltar, John. I need to see. It was an accident. Yeah, I'll call him. Have a seat right behind you if you would. Dale Thomas, 25G306-701. Your name, sir?
Dale Thomas.
Good morning to you, sir. You're going to plead to impeding traffic, right? To that charge, responsible or not responsible? Okay, I'll accept the plea, $150. You can go down the hall and make your payment, okay?
Thank you.
Have a great day.
Two.
Recalling Aaron Arthur Lenz, 25G306-815. Your name, sir?
Sergeant Gary Robinson, you're welcome.
Your name, sir?
Aaron.
Was there injuries?
No injuries, very, very minor damage.
Write that down on that document then, will you please? I'm sorry, on the step form. So you're gonna plead responsible to this impeding, right?
Yes,
You're gonna slow down and be careful, right?
yes, sir.
Okay, because you had an accident back in May of 25. You had a failure to yield in November of 25. Well, I mean, that's what they wrote as hazardous action, November 16. So you've had, what, 3 accidents in 7, 8 months, right? 6 months?
Yeah.
Be careful. Okay, please. To the charge, impeding traffic, responsible or not responsible? All right, I'll accept the plea, dismiss the original charge. 215 is your total cash. You're under the hall to your right, okay?
Thank you.
Amelia Marie Geringer, 25G306780. Good morning, ma'am. Your name? All right. You're going to plead to impede, right? Responsible or not responsible to that charge? Okay, I'm going to accept your plea. I'll dismiss the speeding. All right, $160 and you're all set. Have a nice day. Good luck. Wesley, Mark Solomon Wesley,
Right to the podium, man.
25T647066. Heather, tell Amy, Mr. Wesley's here, please. Good morning,
Okay,
sir.
John.
How are you? How you doing? You're charged with, state your name.
Mark Blessing.
You're charged with fraudulent false information, and you have the right to an attorney. Would you like an attorney?
Yes.
Okay, we'll set you up with a lawyer, and then either way, you're coming back in here, okay?
Can I ask a question?
Sure.
If I show that I have insurance and.
Well, you're gonna have to talk to the prosecutor. Your lawyer will, okay?
Just have a seat in the hallway, sir.
People Against Hines, Zachary Ryan Hines, Q5G306737 A and B. Good morning, Mr. Zelnick.
Your Honor, Mr. Hines, Edward Zelenak for the defendant's Hines Station, please.
Zachary Hines.
Judge, we need a short adjournment. He's going to get into sobriety court. There will be a transportation issue because of where he lives. Taylor said they would accept it. I don't know if you allow lateral transfers. If you don't, then he'll cooperate here. But this is his second, Your Honor. He's a CDL driver with the city of Ypsilanti. His license is over, but because of alcoholism and other health issues, he's going to apply for family medical leave and get into the sobriety court program. There is a transportation problem getting here if you live in Middleton, right?
Yes.
So he won't have a license for some time. And
Well,
I don't
he
know if
won't-
you allow that. And if you don't, he'll come here, judges.
I'd rather have him come here, to be honest.
Oh, that's fine.
I mean, I'll tell you what, let me think about it. I'll adjourn this to the 29th at 8:30. And let me think about it. I just think if it's at a court that has a sobriety court as we do, you know, if at all possible, he should do it here. I mean, Judge Shackelford's got her, you know, she's got her hands full over there with how many she has. You know what I'm saying?
And I explained that to Mr. Hines. It was just an inquiry because of accommodation, but
Let me think about it.
will you be able, sir, will you be able to handle transportation if he needs to get here? Well, no, let's stay here, Judge.
Okay, January 29th, 8:30, and if you want to bring it up again, I don't have a problem with
Thank
that.
you, Your Honor.
Okay.
Just so you know that the purpose is to apply for.
No, I get it. I get it. Okay.
Does he need to see the people here again? He met with them once.
No, it's just next time we should decide he either is or isn't, and if he is, great. If he
He
doesn't,
did, Judge.
okay, good.
Just a matter of coordinating with work because once he pleads, the CDL's history is
Right.
Groff's history, so we need a coordinate.
I got it.
Thank you, Your
All
Honor.
right, have a good day. Be safe out there, Mr. Zelnick, and you too, Mr. Hines.
Thank you, Your Honor.
Kenneth James McKay Jr.
Good morning once again, everybody. The sun is starting to rise here at the TCF bunker. I hope you all are having a great morning wherever you are. Let's change it up. Go to Florida. Wade Mercer.
Mr. Kondracki, good morning, sir. You're here for first appearance accused of one count of driving under the influence with a blood alcohol level of 0.15 or higher. Sir, there is probable cause in the complaint. Your wife and a couple of family friends are in the courtroom on your behalf, and I'm about to address your bond or your release status. This is a bond request, or Mr. McDaniel, is that right?
Yes, Your Honor.
Anything else, Mr. McDaniel, on behalf of Mr. Kondracki?
Your Honor, he's disabled. He gets a disability check from, he lives locally, owns a house. I don't think he has much criminal history, maybe a DUI when he was a minor, 20 years ago, maybe. I think he's gonna have to, I was talking to the Miss Colbert, and he's got to get a referral done through VA, and I don't think they're gonna come out here to this jail and see him. So he has to have two different doctors to do it. They're not gonna do it. So he's gonna have to bond out. We just asked for some kind of reasonable bond, and also taking into consideration, I think he was in a driveway there, on his tractor. I wasn't on a major highway.
The criminal history I've got shows 4 or 5 prior arrests in the state of Kentucky, most recently in 2018 for possession of paraphernalia. Mr. Kondracki, do I have the right criminal history, or is that someone else?
Sound accurate?
That sounds accurate.
Okay, so what happened with the methamphetamine charge in 18? How was it not? I'm not asking you what happened in the charge. I'm asking you, how was it resolved? Was it dismissed? Was there plea, probation? It was dismissed?
Yes, sir.
Was there any kind of supervision imposed before the dismissal, any kind of counseling or anything?
No, sir. It's dismissed in the courtroom by the judge.
Okay. I do see a prior DUI also in Kentucky in 2017. And it looks like a prior, that was in 12/1 of 17, at least a charge. And then looks like there's another prior DUI charge in June of 17 in Kentucky. So that's what the criminal history is showing. It's not showing convictions. It just shows the charge without showing any dispositions. Let me see if the state has any additional information. Mr. Mitchell, anything?
We just request that as a condition of his bond, he not possess or consume alcoholic beverages.
Okay. Mr. Kondracki, based upon your criminal history, I'm going to set your bond at $3,500 cash or surety. You have a condition not to possess or consume alcohol at all because this is allegedly you're accused of an alcohol-related DUI. You've got that condition that you cannot possess or consume alcohol. If there's information or reliable information that you are possessing or consuming alcohol, that would violate the condition of your bond and you would go to jail or you could go to jail with no bond. It's cash or surety. That means you can go through a bondsman if you wish. You also have the right and option of putting up the whole amount if you wish. Let me see first if your wife has any questions, and we'll see if you have any. Ma'am, do you have any questions? No questions. Mr. Kondracki, do you have any questions?
I do not.
You'll get used the phone shortly, sir. If you post the bond, you'll be released. I'm also going to ask the jail to give you a notice for your court date. Will that be the 2nd?
Yes.
February 2nd at 9 a.m. will be your court date. The jail will give you that notice after first appearance. Wish you the best, sir. Any questions at all? All right. Wish you the best, sir.
Don, what is that cutoff for the 2nd? Okay. Yeah.
Next case is Tony Rout. Tony Rout. Mr. Rout, good morning. Mr. Rout, you're here for first appearance accused of one count of possession of drug paraphernalia. Mr. Rout, there is probable cause for this charge. I've also looked at your extensive criminal history, Mr. Rout, so I'm aware of your criminal history. I think you're entitled to a bond as far as I can tell, but I'm going to listen to the attorneys before I make that decision. Mr. McDaniel, anything on behalf of Mr. Rout?
No, Your Honor.
Mr. Mitchell.
We just request to be subject to random UAs.
Mr. Rout, it looks like you've been to, I think I made a note, been to Department of Corrections 4 times, been in prison 4 times. Is that right, Mr. Rout?
Yes, sir.
Okay. So I'm going to set your bond at $5,000 cash or surety, Mr. Rout, with a condition of random urinalysis. You have the right to post the bond. Cash or surety means you can put up all the money or you can go through a bondsman. That's entirely up to you. Some places call that a professional bond. It's the same thing. Mr. Rout, you do have the condition of random urinalysis requested by the state, and that means you can be drug tested at any time. If you have anything in your system that you don't have a valid prescription for, then that would violate the conditions of your bond. You could go to jail with no bond. Mr. Rout, I'm going to ask the jail to give you a notice for your court date. That's going to be February 3rd at 8:30 in front of Judge Garcia. And Mr. Rout, you will get to use the phone in just a few minutes, sir, to try to post that bond. Mr. Rout, do you have any questions?
Yes, sir.
Wish you the best.
February 2nd court date in front of Judge Mercer.
I was about to say, yeah, I think this is the.
Well, I thought this was a felony, but you're right. This is a misdemeanor, so it'll be February 2nd, not February 3rd. I was giving you the felony court date, but it's actually the misdemeanor court date. You're accused of paraphernalia, so it'll be February the 3rd.
February 3rd.
It'd be February 2nd at 9. February 2nd at 9. Next, we have Richard Collette. Mr. Collette, good morning. Mr. Collette, you're here because you've been accused of one kind of battery on the elderly. Mr. Collette, there is probable cause for this charge. In addition to reading the complaint, I've also looked at your criminal history. You have several prior charges or arrests. So, Mr. Collette, I think you're entitled to a bond as far as I can tell. Let me see if the attorneys have any additional information. Mr. McDaniel, anything?
Nothing, Your Honor.
Mr. Mitchell.
Anyway.
Just a second, Mr. Collette. Let me hear from Mr. Mitchell, then I'll see what your question is. Mr. Mitchell.
Let me double check something right quick. The complaint does make an allegation that he may have been under the influence of some substance. It doesn't say if it was alcohol or something else. I guess the state would be requesting that he be subject to random UAs. If that's possible, we'll leave it up to the court.
Tell me where that's at so I can read the language they use. See, I see it right there. It was apparent that Collette was under the influence of some substance due to him staggering while walking and slurring his words. They don't mention the smell of alcohol.
No.
Okay. Mr. Collette, you wanted to say something?
It was alcohol.
Okay. All right. So,
Me and him,
Mr.
both,
Clay,
me and that other guy were drinking it.
okay, Mr. Clay, anything else that you wanted to tell me, sir? Don't talk
no,
about the charges, but you were trying to say something a moment ago.
It slipped my mind
Okay.
that quick.
Okay, Mr. Collette, I think you're entitled to a bond. I'm gonna set you the normal felony bond. It's gonna be $5,000 cash or surety. Cash or surety, Mr. Collette, means you can go through a bondsman. You do not have to come up with all the money. If you go through a bondsman, they'll negotiate with you what they charge you, but normally it's around 10%. That'd be $500 to get out of jail. Mr. Collette, you do have a condition not to possess or consume alcohol based upon the allegations allegedly involving alcohol. Mr. Collette, you will get to use the phone in just a few minutes, sir. You post that bond, you'll be released. If you don't post the bond, the public defender's office will be in contact with you. And Mr. Collette, the jail will also give you a notice for your court date, which should be February the 3rd at 8:30. Mr. Collette, do you have any questions?
No.
All right, sir. Wish you the best.
No.
We have Angela Martin.
He didn't say nothing about no contact with a victim.
Oh, yeah.
Yes, there is a condition, no contact with the victim. Thank you, Corporal. Mr. Collette, there's an administrative order that requires I do the condition, no contact unless the person's here. It's okay. It's fine. Just no contact with Mr. Harrell, Mr. Collette, okay?
Okay.
Next case is Angela Martin. Miss Martin, come on up. Miss Martin, you're here for accused of one count of aggravated battery. Miss Martin, there is probable cause in the complaint. Ma'am, I'm going to go ahead and set you a bond in this case because I think you're entitled to one.
We're going to just hopefully just resolve the misdemeanor case and, not just mess with the other one. I don't think the other one's going anywhere with her husband. I mean, he's already been calling me this morning, but we're going to resolve the other one if the court's.
Sure, I have no problem with that, but I still need to set a bond in this case, don't I?
Correct.
Okay.
Yes, Your Honor.
So in the new case, any input on the bond in the new case, Mr. McDaniel?
No, Your Honor. I mean, just based on the facts.
I didn't interrupt you, Mr. McDaniel. You were saying something. I'm sorry.
Just, based on the facts of the case, I'm sure the court read it, so.
I did. Thank you. Mr. Mitchell.
As it pertains to the new case, that may be the case, as Mr. McDaniel is saying. We haven't heard from the victim yet. I'm sure we'll probably hear something today. But as for right now, we just request the court take into account her history when it comes to the batteries that she's been convicted to and set a reasonable bond under those circumstances.
So, Ms. Martin, I know there's several battery charges on your history. I don't see dispositions on most of those, but I know there's charges. So I'm taking that into account, not convictions necessarily. But Ms. Martin, I'm going to set your bond at $10,000 cash or surety on the new charge. Condition of no contact with the alleged victim. You do have another case that Mr. McDaniel and Mr. Mitchell have already alluded to, and that's one you're out on bond in, 25-552 MM. In that case, I've already appointed the public defender's office to represent you. Please listen to Mr. McDaniel in that misdemeanor case.
Your Honor, I spoke to Ms. Martin. She's going to plead no contest to the charge. Understanding she's going to be sentenced to 90 days in the county jail. She'll have 3 days jail credit. It'll be $722 fine. And she is going to waive her right to a jury trial and call witnesses. And that'll resolve that case today.
Thank you. And Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Ms. Martin, did you hear that agreement in the misdemeanor case?
Yes, sir.
Do you have any questions about that agreement?
No, sir.
Ms. Martin, is that the plea you would like to enter to resolve that misdemeanor charge?
Yes, sir.
Ms. Martin, I'm going to accept your plea of no contest in misdemeanor battery case 25-552 MM. Withhold adjudication of guilt, the judge of guilty sentenced you to 90 days in jail, 3 days credit, $722 to court costs and fines. That'll be a civil judgment if you don't get it worked off at the jail, and hopefully you will get it worked off. So that resolves the misdemeanor case. In the felony case, the jail's going to give you a notice, ma'am. Your court date should be February the 3rd at 8:30. And Ms. Martin, I don't know if I said it earlier, but you've got a condition of no contact in the new case. Now, if you and the alleged victim both want to have contact, certainly we'll consider that. But for right now, we have to do no contact. Ms. Martin, do you have any questions about your sentence?
No, sir.
Have a good day, ma'am.
Your Honor, I think that'll take her off the pretrial docket and the trial docket.
Thank you. Mr. McDaniel, Mr. Mitchell, did you get the text about the changes for next Tuesday's first appearance where I was going to be out and now I'm no longer going to be here?
Yes.
Okay, so we'll make sure we're all on the same page. The other thing is that Judge Garcia asked if I could cover first appearance for her Sunday. And so I said yes, but since it's so late, she and I decided just to stick with the original assigned team. So I'll use her assigned
Team.
ASA
Okay.
and APD, so you don't have to worry about it.
Okay. That was going to be my next
And
question.
then eventually down the road somewhere, she'll take one day of my weekend and we'll trade it out somehow.
Okay.
So that's all I had today. Mr. McDaniel, anything else from the public defender's office?
No, Your Honor.
Corporal, anything else from the jail?
No, sir.
And Mr. Mitchell from the state?
Nothing from the state, Your Honor.
Ladies and gentlemen, that concludes first appearance.
That does indeed conclude first appearance. Good morning, everybody. TCF Live. It's Thursday. Sun's coming up here. Looks like it's going to shine bright today. I'll let our weatherman give the full forecast for the greater Phoenix area. But whatever's going on in your world, I hope you're enjoying your morning so far. And thanks for joining us here. Let's... a lot of courts still waiting to come online, but let's, for now, let's go back to Judge McNally.
I don't have him on Zoom, Judge, so I'm not sure if he's here in person.
You wrote here, John.
He's on Zoom.
Do you see him?
No, I do not have him out here.
I got him.
Oh, you know what? You do, John. You don't have me as a co-host. That's why I don't see him.
Okay. This is again, officer, you can start your video. Kenneth James McKay Jr., 25B149883. Your name, sir? Again?
Kenneth James McKay.
All right. Officer, your name?
Officer Gage McFarland, Brownstown PD.
All right. Do you still wish to continue with your not responsible plea? You wish? Okay. I'm going to ask you both to raise your right hands. Officer, let me see your hand, please. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God.
I do.
All right. So you've both been sworn in. You can proceed, officer.
Yes, sir. On the day of the incident, which I don't have in front of me right now, unfortunately, I got a call to the area of Huron River Drive, just west of West Jefferson for an accident. When I arrived on scene, I seen two people pulled over to the side. One individual said that he was attempting to turn left to a private drive, and that Mr. McKay was impatient and went around him at the time he was turning, and unfortunately, the two collided.
So is the alleged victim here traveling eastbound or westbound?
He was traveling westbound, sir. Both parties were traveling westbound.
Both were traveling westbound. So the defendant was going to, the individual with whom Mr. McKay was involved in an accident with was going to turn left onto southbound Huron River Drive. Is that true?
He was going to turn southbound, but it was into a private drive, Your Honor.
I got it. I'm sorry. I misspoke, really. And then Mr. McKay was driving westbound as well. And there was a collision in what? The eastbound lane of Huron River Drive?
Affirm, sir.
I'm sorry?
Yes.
Do you have any questions for him, sir?
Yes, I just want to confirm that you recall driving eastbound, and then making a 3 or 4 point turn to turn around to tell us both to proceed forward and then turn left onto the side street there.
Are you talking about after the accident?
Correct, yeah, when he got there.
Yeah, I told him to turn down a side street over there. Correct.
So you can investigate the accident?
Yeah, and get him off the road right there.
Right. Okay. What other questions?
I don't have any other questions for him, just the defense in the video that showed there was no.
Do you have a video?
I do.
Where's?
I don't have a video of the accident. I have a video of directly afterwards that shows his cruiser there and the other vehicle there to show that it was the day this happened. There was no debris on the road. There was no yaw marks. This was a very low speed collision. The other vehicle actually turned left and hit the side of my car. I was already alongside this person. This happened in a passing zone. He was stopped in the middle of the road with no turn signals on. I am a professional driver. I was in a Ford Focus that is very low to the ground. He was in a Ram pickup truck. His taillights were in my face.
Wait a minute, slow down. So you're traveling west behind him. How far are you behind him? Initially, before you decided to pass?
Close. He was going slow. He was going dangerously slow for that area.
What do you mean dangerously slow for that area?
So if you're heading south on Jefferson, you go around on the Current River Drive, there's a turn road.
Right.
And people go around that road 45 miles an hour. And he was going maybe 5 or 10 miles an hour. And people come around that road, and I was afraid of getting rear-ended. And then he proceeded to go slow. And
What do you mean you were afraid of being rear-ended by who? Was somebody behind you? Okay, but, so you decided to pass?
Yes, in a passing zone, I decided to pass. Because there was no turn signals on this vehicle. I was under the impression that maybe he was irritated that I was there because he was going so slow. So I went to pass and I got alongside him and he turned into me. The damage on my vehicle shows that he also turned in.
All right, slow down a second. Were there any injuries here, officer?
No.
And Your Honor, I do have something else to say whenever you guys are free.
No, I know, but I want to ask you that question first. Were there any injuries?
No injuries, Your Honor.
And was there serious property damage to the other vehicle?
No, sir.
And you don't want impeding traffic?
No.
Okay. All right, what do you want to add, officer?
On Huron River Drive, just west of where the accident did occur, I went back and I investigated that area. It's a permanent yellow line, which you're not allowed to pass. And I know the accidents happened there because the victim driver said, hey, it happened over there. And there's a solid double yellow line over there and you can't pass. So I said, okay, I'll go back and investigate. So I did go back and investigate that area. And the accident did happen there because there was very minor debris on the road. And there were clear yaw marks where the individual, Mr. McKay, clearly tried to go around where the victim said it happened. So there were tire marks in the lane. So he was not supposed to pass in that area, but he still did. And that was the area that
That's why you wrote him for improper lane use.
Yes, sir.
I disagree. I have video that shows no yaw marks and also.
If you want to show me any video, I have no issue with that. I'll be glad to look at it. I'm not sure that if it doesn't show me if it doesn't depict the accident.
Well, it shows where I was pulled over because you can see my tires, because I went on the shoulder. The other vehicle did not go on the shoulder. I went to the shoulder after the accident.
I'll be happy to look at whatever you want.
Take me just one moment to find it. How do I get it to you?
You can hand me your phone. You can't see this though, can you, officer?
So
unfortunately not, Your Honor.
The problem is you may have.
Can we get that up there? Would it be hard?
I don't know. This may have to be Shane. Don't call Shane.
Yeah. See if he can do that real quick.
You come in there, judging down script. I have a suspicion that the marks that he was seeing were possibly where he arrived on the scene and turned around, because I can see all his marks in this video. And also where somebody backed out of the driveway.
I think what he was telling me is that the debris was in the zone that was a no passing zone. Is that not what you're telling me?
There was nothing missing from my vehicle. I don't know what could have been missing from his vehicle. His tire hit my car. There was nothing missing from my vehicle. Zero debris, zero breakage. I have video of the vehicle as well.
Do you have vehicle of the area where the impact occurred?
Yes, I do. Where I believe it occurred due to the marks on the pavement. So what happened when he turned into me, There was a Dodge Ram pickup, like I said, he turned into me and his tire hit the right side of the car and it knocked the toe in on his vehicle. And you can see where he pulled away. You can see where the yaw marks are from the toe in his truck.
Was there any indication as to whether or not he had his turn signals on, officer?
Mr. McKay said that's what happened. When I asked the victim driver what happened, he says he did have his turn signal on and that Mr. McKay was impatient and went around him because he was going too slow. And then the reason for them pulling up, hold on a second, Mr. McKay. The reason for them pulling up is because where the accident occurred, according to the victim, there's also another lane that kind of comes diagonal from southbound West Jefferson. So they had to get out of that area. So they all pulled up more westbound on here on River Drive because you don't want to be kind of caught in that area, that intersection area where the victim driver said the accident occurred.
Which is precisely why I was trying to pass this person, because it's a dangerous area. And as the officer stated, the driver said,
Hang on one second. Can you get that up on the screen?
Shane said he's gonna have to zoom in.
You're gonna have to zoom in on your phone and share your.
Yeah, I don't know how to do it. So I'm a very simple person.
Or you can show your phone.
Let me see it. Let me see it, though. Let me see it.
I don't know. You're gonna have to play it again and again. I just explained to you the video. It shows where the double yellow ends.
Just hand it to me. Let me take a look. I can't see a thing from where you are.
It's very clear that there's no debris. You zoom in.
Yeah, and it's phone.
At the very end of the video, you can see the officer's cruiser pulling away towards me. And at the end of the video on the right, is where my tire track is, where I pull away onto the.
What am I looking at now? I'm seeing a car.
I don't know, because I can't see.
Well, I'm looking at a car. Is that from your vehicle, right? Well, this is after the accident, right?
Yes, that's correct. I had to document the area in order to.
I'm not sure why I'm looking at this. Why am I looking at this if it was after the accident?
Show you that number one, there's no debris. Number two, the tire tracks that are seen are from people backing out of their driveways, or when the officer arrives, his 3.4 turn he did.
Can you have this put up there? I want this officer.
I don't know how to do it, Judge. He's gonna have to zoom in with your Zoom
You
ID.
can Zoom with my Zoom ID and we'll get it on the docket here. Just be patient with me, officer, please. Okay, I'll be right with you.
No problem, Your Honor.
Kimberly Ann Rose. Somebody can help you.
Yeah, I'll send him the right person.
25T647291. Good morning, ma'am. Your name? You're charged with driving on a suspended license and you have the right to a lawyer. Would you like an attorney?
Yeah.
Okay. We're going to give you an attorney. You go out in the hallway. Your lawyer will talk to the prosecutor and then you'll come back in front of me. Okay? You're welcome. Good no. Darren Michael Goodnow, 25T647391. I have A, B, and C. I have an unauthorized or improper use of lights, no insurance, and driving on a suspended. Your name?
No.
All right, so you are here for arraignment and pretrial. You're charged with a misdemeanor, drive while suspended, and 2 civil infractions. You have the right to a lawyer. Would you like one? I'm sorry? I'll go ahead and arraign you. I'll send you to the prosecutor then, okay? It is alleged that on December the 26th of 25, that you were operating a motor vehicle in the city of Trenton and may think that you did not have a valid license, that it was suspended. They think you were driving on Grange and West in Trenton at 8:10 p.m. on that date. That is a misdemeanor punishable by up to 500 fines, 90 days jail, costs of all those, and 2 points. Do you understand that? You also have 2 other charges, no proof of insurance and unauthorized or improper use of lights. Do you understand that? And did you sign, read, and understand an advice of rights form here today? If you plead guilty, you will be giving up all those rights and we're not going to have a trial. Do you understand that?
Yes, sir.
You still wish to waive your right to a lawyer? I'm entering a not guilty plea. $500 personal bond. You don't have to post any money.
I have,
Hang on. You don't have to post any money, but you cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. You understand that? All right, so you go out in the hallway, he'll call you in momentarily, all right? Funchess. Kiamora Rain Funchess, 25B 1499618 and B. Do you have any more files down there? Funchess, is she out on Zoom?
She's on Zoom, Judge.
Okay. Your name, ma'am?
More Funchess.
You're charged with driving while unlicensed, and you also have a civil infraction, a failure to yield. You have the right to a lawyer. Would you like a lawyer?
Yes.
All right, you just stay put. I'll be with you momentarily. We'll put you in a waiting room, and then as soon as they're ready, they'll zoom in and talk to you. Okay, so this one wants a lawyer, John, and they do not.
This one going to.
That is just going to waived attorney, so that's going right to the prosecutor. And then this one is this young lady right here. She's on Zoom, and she wants a lawyer. Eric Anthony Schilling, 25G 306-772. Your name, sir?
Eric Schilling.
Good morning to you. You have a charge. You met with a department rep. You're going to plead to impeding traffic, right?
Yes, Your Honor.
To that charge, responsible or not responsible?
Responsible.
All right, I'm going to accept the plea. $160. You can go down the hall and make your payment, okay?
Yes, correct. Thank you.
Your speeding is dismissed. Good luck. Happy New Year. Murphy Holding LLC, 25P 647-033A. And I also have, give me 1 second here. I have 647-033A, B, C, and then I also have 647-037, A and B.
Good morning.
Good morning, Mr. Gunther.
Good to see you. Sir.
You too.
Yeah, I think they wrote the same ticket twice. I was talking to the prosecutor about.
I need your appearance first.
I'm going to please the court, Patrick Gutner, P70106, appearing on behalf of the defendant, Murphy Holdings LLC, who's representing Christopher Murphy's here to be taken.
Let me call him, man. I can't even make heads or tails out of this, what he's written up here. Okay, sir, your name?
Chris Murphy.
All right, so first of all, he has a charge of commercial vehicle, no plate. Does he stand waive formal reading on that charge?
Yes.
I'm gonna need you in here, Mr. Bologna, please.
Oh, yeah, okay.
Thank you. Same thing on file C, the insecure load.
Yes.
All right, so those are the two misdemeanors I have. Now I have 3 civil infractions. I have a safety equipment, flares, no medical waiver card. Hang on a second. Yeah, I have safety equipment violation flares. I have no medical waiver card. That's just, I'm having a hard time making heads or tails out of this one, Mr. Bologna. Then I have a B, well, it's not your fault. I have a B file, no insurance. So I have 647033 that has no trailer plate, commercial vehicle, no proof of insurance, commercial vehicle, an insecure load, commercial vehicle. Then I have on 7037A, which is the same offense date, I have a warning on the operating without a proper endorsement, and I have safety equipment violation, flares / triangles, and no medical waiver card. So I want to make sure that I'm doing this right. So first of all, you've got improper display down here. What file is that on?
We're amending the charge here. We're adding this.
Yeah, I know, but you got 5 cases
That
here.
would be on the plate violation, which was a misdemeanor.
The 3-3 case.
Is that the A file or is that the B file? That's A file. All right, so you're dismissing the original charge, no trailer plate, and he's pleading to improper display, right?
Correct.
Yes.
All right, let me just take one of these at a time. All right, so I understand that one. Now we've got, you got a B and C case here on 7033A. Am I right that he's pleading to no proof of insurance on that one? And he's also, that's file B, and he's also pleading on 647037A,
Safety.
the safety equipment, is that right?
That's correct. That's correct.
Give me 1 second. All right. And then I've got, you're dismissing the no medical waiver code, right?
Correct.
Why didn't your client show up first? He wasn't here, was he? Maybe, I don't know why we entered a default judgment on December 4th. All right, dismissed for STIP, that's on no medical waiver card. And then, what am I doing with the last file? You got, I think you only have 4 written up here. He's also got a, so I've got him pleading as charged on 7037A, pleading as charged on 7033B. 7037B is being dismissed. He's pleading to improper display on 703A, and I don't think you did anything on the insecure load.
That's a dismissal.
That's a dismissal? Okay, you got CMV load, I see now. All right, do you understand all of this, sir?
Yes, sir.
Okay, so to the charge of improper display of plate, responsible or not responsible?
Responsible.
To the charge of no proof of insurance on behalf of the company. What's your position, by the way?
Owner.
So you're the president?
Yes.
So to the charge of safety equipment violation on behalf of the company, file 7037A, responsible or not responsible?
Responsible.
And to 7033B, no proof of insurance, responsible or not responsible?
I think what the government needs to know about, is split out. I think so.
Yes.
Yeah, I think there was a plea on that one, Your Honor, to authority to split it out, and he'll.
No, he's pleading to no proof of insurance according to this.
I think that was actually amended to unable to display valid proof of insurance.
It's the same.
Well, what's the same?
Yeah, I think it's the same.
Same charge. It's no proof of insurance.
Okay.
They didn't charge him with a misdemeanor of no insurance.
Yes. It's just a lower, yeah.
So to that charge of no proof of insurance, responsible or not responsible?
Responsible.
To improper display again, responsible or not responsible?
Responsible.
Just violation of the safety regulations on file A, responsible or not responsible?
Responsible.
All right, good enough. Give me 1 second here.
Thank you.
Just a little confusing. Oh. Does he have insurance now?
Yes.
You can't be driving a commercial vehicle without insurance, sir. Right? All right. On the no insurance, they didn't write that one as a commercial. I'm doing $200 on that, on the improper display, $210, and on the defective equipment or safety violation, I should say, $235. So he owes $235, $435, $645. Can he pay all that today?
Yes, you.
All right, Mr. Gunner, good to see you. You doing all right?
Judge,
Yeah.
can I ask what file was the improper plate? I'm sorry, that was a lot. I was trying to keep up.
I know. I know it was on the note 7033A. He's pleading to improper display,
Okay,
and they're dismissing the no trailer plate.
okay,
So they're dismissing the misdemeanor. He's pleading to a civil infraction of improper display. On 7033C, which is unsecure load, they're dismissing that. On 7033B, he's pleading to that, no proof of insurance. On 7037A, he's pleading to that, which is safety equipment,
Safety
flares,
equipment, yeah.
triangles. And then they're dismissing 7037B, which is no medical waiver card.
Okay, thank you.
Okay, no problem. You're all set. Have a good day. Happy New Year.
All right, I'm going to keep an eye on Judge McNally's court for when that driving case comes back. But in the meantime, let's go to Washtenaw County, spend some time with J. Cedric Simpson, just taking the bench.
Snow is real. That's all I'll say. And so are ditches. Please.
Good morning, Your Honor. Raymond Cook for the people. Your Honor, the people believe any potential conflict between this honorable court and the office of the public defender. While the people do not believe that any such conflict exists, the people make this waiver in the avoidance of all doubt.
Gaines.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender. Your Honor, we too, with the Public Defender's Office, do not believe that there is any conflict, but if there is, we will waive any potential conflict.
The court, for its part, also does not believe that there's conflicts either in Michigan court rules or the cases decided thereunder to the extent a conflict does exist. Given the waivers, the court will consent to hear the matters. Court does call the case of People State of Michigan versus Ryan Milligan.
Morning, Your Honor. Raymond Cook for the people.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr. Milligan.
Mr. Milligan, can you state your name, please?
Ryan Joseph Milligan.
Your Honor, I did reach out to the Department of Corrections to try to arrange to meet with Mr. Milligan in person. I was unable to speak with an actual person to make that arrangement.
Got it.
I would ask for a short adjournment, maybe 2 or 3 weeks.
Probable cause conference will be adjourned to February 5th. Yes, sir.
What's going on now? Do I have to see somebody or something?
Yeah, your attorney would like to meet with you. She tried to contact the facility and I guess, if I'm correct, Ms. Gaines couldn't get through to anybody to try to arrange that meeting to talk to you.
So she's gonna come up here? This is like my 4th adjournment, I think.
This will be your last adjournment.
Okay.
Not really. You might be talking about other cases. I think it's your second one.
Well, this will be your last
They
adjournment for this.
rescheduled it for 4 too, but. Okay.
I will make sure I see you.
You'll come up here and see me?
Yes, I will.
Okay, thank you.
You're welcome.
February 5th, 2026, 9 a.m. Bound will continue. Thank you.
Thank you.
Thank you, sir. I have a lot on my schedule. Court calls the case, People versus Romeo Smith.
Alex Jablowski for the people.
Michael Gaddy, Assistant Public Defender for Mr. Smith, Your Honor.
See Ed? Oh, there he is. Mr. Smith, can you state your name, please?
Muhammad Martinez Smith.
Thank you. What are we doing?
Your Honor, we have received a competency update. I've had a chance to go over it. I have not been able to see Mr. Smith at the Forensic Center. The report indicates that in their opinion, that he is not competent, but restorable. By my estimation, that date is February 8th.
Pardon?
I said, by my estimation, I think that restoration date is February 8th.
February 8th?
May we approach, Judge?
Yes. Thank you. What do you want me to do?
Okay, friends, he's muted, and I'm still waiting on McNally's court. So let's go to State of Michigan. Let's go to Judge DeSanto.
Judge.
My name is Braxton Bailey.
Okay, good morning. And today is the date scheduled for the adjourned probable cause conference. And counsel?
Your Honor, I did discuss the matter with Mr. Bailey. I also have discovery, and we elect to have our preliminary examination We will waive the 21-day rule and request that the exam be scheduled for January 29th at 11 a.m. per the prosecutor's agreement.
Okay, well, first I need to check to see if that works for the court for the date and time.
Okay.
Does that date and time work for us, Ally?
Yeah, we can do the 29th at 11.
Okay. January 29th at 11 a.m. works for the court.
Thank you so much, Your Honor.
Any witness and exhibit lists
No, not for the exam.
by January 26th?
Understood, Your Honor.
Counsel, if you could just go over the time waiver with your client on the record, please.
Yes, Your Honor. Mr. Bailey, you are entitled to have your preliminary examination within 21 days of arraignment. The time that we have scheduled is past those 21 days. Do you agree to waive that time constraint to fit everyone's schedule, Mr. Bailey?
Yes.
Thank you.
Okay, the court will note that time has been waived on the record. And then the court will also order bond and conditions are continued.
May I address that just briefly, Your Honor?
Yes,
this is
so do you want to address the bond conditions?
Well, yes, Your Honor. Just briefly, the home was owned by one of the family members of the complainant. Mr. Bailey has received an eviction notice and would like to be able to go to the home to remove all of his property. So we just simply ask that he be able to do that.
Has there been a, well,
my understanding, there's been a 30-day notice filed only, but my understanding is that neither the complainant nor Mr. Bailey is staying at that house right now. It is his intent to just remove all of his belongings from the house and be done with that.
here's what I'm going to, so sir, do you have furniture or personal belongings? What is it that you have?
Personal belongings.
How long do you believe that it will take you to remove those items from the home, sir?
This will be at least a 2 to 3 hour project. I've been living in the home for about 5 years, so I have a lot of clothes, a lot of gym shoes, and just a lot of collectibles.
Okay, so what I'm going to do, counsel, is I'm going to have you go back into a breakout room so you can coordinate with the prosecuting attorney and the victim advocate to confirm that the complaining witness does not reside there anymore, nor does she have any property there, nor will she be returning there if she does have property to remove that property.
Your
All
Honor,
right?
I'm sorry, it is expected, she does live there and it is expected that she will stay there. Her family member owns the home. I believe that she's just staying away until Mr. Bailey leaves.
Well, so therein lies the issue, counsel, because I'm not going to have your client at the house where the complaining witness resides without having police escort. The police escort will not stay for 2 to 3 hours. It will be a short while, probably not more than 15 minutes. So here's what what I'm going to do, sir, is I'm going to make sure that my criminal and civil departments coordinate so that I'm not going to proceed with an eviction in this matter until we know what's happening with this matter on the 29th. If they filed an action in this court yet, it may have just been a 30-day notice to quit. I don't know if there's been a summons and complaint issued or not. Actually, we're gonna look that up. Can you look that up for me, please, Ally?
Like business.
Yes, in the civil.
I don't see this email.
Okay, so far, council, there's been a 30-day notice to quit. There has not been an action for a summons and complaint filed. So I don't know, council, if you'd like to speak to the owner of the home that filed the 30-day notice and coordinate what that looks like. I'm not sure, but at this point, this court's not going to make any amendments to the bond condition in that regard. I don't know if your client has a third party that would be acceptable to the complaining witness to box up his items. I'm not sure, but I'm not having your client there without police accompaniment, and they will not be there for 2 to 3 hours. That can't happen.
Okay, Your Honor, we'll think of something that won't violate the court's order.
And I'm also going to indicate that I expect that there won't be any destruction of Mr. Bailey's property as well.
Thank you so much for that, Your Honor.
Okay, bond and conditions are continued. We'll see you back in 2 weeks. Thank you.
Thank you.
All right, let's swing back to Judge McNally's court now for what appears to be a continuation of the driving thing we saw earlier.
All crazy, right? Sadie, you're on YouTube now.
All right.
Okay. All right. Now.
I'll find the video.
Okay, Officer McParland, start your video again. Recalling Kenneth James McKay Jr., 25B149883.
Kids and technology.
I got news for you. He's younger than you are.
This guy? Yeah, of course he is. Like 40.
He looks 10 years younger than you.
Should be still in this. You scroll, what was the date? Scroll down.
Yeah, it's John.
Yeah,
The photos, but not this.
That's where it would be. Okay.
It's not there, just the photos.
The Zoom number to me to reach him when I end during back up these two.
Okay. Good. Good. I think you made other. Okay.
It's not giving an option to share any videos.
It's not giving an option to share the screen.
No, we can share the screen. It's just not showing.
It's not showing videos. All right. I'm sorry. We tried.
Your Honor.
Yes, you're still under oath, by the way, officer.
Of course, Your Honor. I also have, I'm lucky enough to be off today. I do have a map in front of me so I can better explain to the court too and show you on Google Maps if it's okay with you in the court to show you how far this yellow line does go if that's okay with you.
Absolutely.
It's very clear on the video how far the yellow line does go. It's very clear where I was stopped on the shoulder.
Here.
Okay, just wait. Let me look at what he shows me first, okay?
Of course, Your Honor.
My concern here is, even if you were in a passing zone, I got testimony here that the guy had his turn signal on.
And me, a professional driver, I have driven 500,000.
What do you mean a professional driver? You have a CDL?
Which license I have a transportation company. I am testifying right now that the man's lights were in my face and there was not a turn signal on. I would not have, as a professional driver, I would not have passed this person had there been turn signals on. The officer stated himself that the person felt that I grew impatient and passed him. That proves that he knew I was back there. And I believe that the other person may deny this, that he did it intentionally, that he was going.
Got in an accident intentionally?
They didn't get my car intentionally. He was going dangerously slow. First of all, this was an elderly person. He was looking for a home that he must be unfamiliar with, because that's what he told the officer, that he was going to somebody's workshop there. Must be an address that he's unfamiliar with. That must be why he was going so slow. So I was behind him when it got to the point where I could get around him. I did. It aggravated that person that I was doing that. And he.
Well, you don't think he intentionally slammed into the side of your vehicle, do you really?
I have a suspicion that that is part of it. The officer said himself that he thought that the other person thought that.
Okay, you're gonna lose me on that.
Okay, well, that's fine.
All right, go ahead. Show me what you want to show me, officer.
Yes, Your Honor. I'm going to go ahead and just try to turn the video around. Do you know in the court in the app settings, if that's possible? If not, I'll do my best to go ahead and turn around so I can go ahead and explain it to you on the monitor I have in front of me.
You guys ask me technology questions and you expect me to know the answer, huh? You should know better.
My apologies, Your Honor. I'll do my best right here. Let me know if you can see my, Your Honor.
Yeah, I can see it.
All right, Your Honor. So this is West Jefferson.
And you can see it, right?
Yes.
Okay, go ahead.
All right. So as you can see, there's another lane, like Mr. McKay and I said, that comes in through here. Okay, so if I just click like this and I go to the street view, here's that lane that comes through here, southbound. Now you see this double yellow?
Yes.
This is where, in this area, forgive me, that all the way up to this bridge that the victim driver said the accident happened in. And as Mr. McKay and I previously stated, they both had to get out of this area so that way they wouldn't get hit. You know, they can't just stay right here. So if you go, this yellow line, as you can see, it goes down quite a ways. I'm zooming in, zooming in, zooming in, again, until we almost hit a street down here called Ludwig.
How much? Hang on, slow down. How long would you say? Now, it's hard for me to tell that double yellow line exists there on that roadway. Can you give me an estimate?
As far as yardage, Your Honor?
So you're saying it happened west of there?
It happened well west of there. The tire tracks on my video show exactly where it happened and exactly where my vehicle was stopped on the shoulder.
And it
was nowhere near that area. It was at.
Where were they when you told them to move their vehicles? When you arrived on scene, where were they?
They were in this area between, just past this. They were in this area right here to this area over here. I would say it's about a good, probably 70 yards, Your Honor, 60, 70 yards.
From the end of the double yellow line?
Yeah. No. So from the line over here, which is the double yellow, the ending of it, to where I found them, which is over here.
Over where? Show me.
They pulled up. They were in this area. Okay.
All right.
And they said, the individual said the accident happened like in this area right after where that southbound lane, like Mr. McKay and I said. And then I found there's a private drive. I don't know which private drive it was, but there were yaw marks that were like not 3-point yaw marks. They were yaw marks that go like this around, which clearly show, that someone was trying to go around, not someone pulling out and then going forward.
And you saw debris in that area? Is that where you saw the debris?
Yeah, there was minor debris, Your Honor. And my apologies, I didn't get down and look at like what kind of debris it was and trying to verify which, could have been from another vehicle, of course. But from where the victim vehicle said that this happened, I'm certain it was Mr. McKay's vehicle, and it was definitely within the double yellow, and it was clearly double yellow in the area that the accident, the victim said, occurred.
All right, what do you want to say?
I want to say, I want to be able to show you frame by frame my video. So I can prove to you where this accident happened.
Where are you going to show it? I got to have.
I have it on my phone. So I don't know. The officer should be here. That's what should happen. The officer should be here.
Well, we don't make them come here. And in fact, if you wanted to do an informal, I'd let them come here. Where are you now?
Where am I? I'm at my residence, Your Honor.
Yeah, what city?
Judge,
I'm in
what?
Shane said if he emails the video,
Go down and talk to John. You go down to the end and talk to the tech guy and see what we can do. Okay, let's do that. You go down and talk to the tech guy. Go all the way down the hall and they'll bring it up for you. All right. Just bear with me, officer. Teresa Lynn Little, 25T642922. Multiple misses from this young lady.
All right, so it looks like we're waiting again. It's like the hearing that will never end. Let's go back to Judge Simpson.
Hopefully that will come in. He can get to you. You guys can discuss it. You can figure out exactly where you are on this. All right? Fair enough? Bond will continue. Thank you. Court does call the case, People versus Christopher Decker.
Morning, Your Honor. J. Grant Miller, on behalf of Mr. Decker, he had stepped down the hall to go to the bathroom. If you could pass it for just a few moments.
Court does call the case, People versus, have I in custody yet? Court calls the case of the People versus Brandon Dempsey.
Good morning, Your Honor. J. Grant Miller, P58658, on behalf of Mr. Dempsey, who approaches.
Brandon Dempsey.
Your Honor, I actually been talking with my client. I'm going through all the discovery. I believe we have everything. So if we, instead of an adjournment, if we could just set for an exam 4 weeks out, I think that would be sufficient. 4 weeks.
Why?
We need to go through all of the videos, Your Honor, still. I just got a couple of the videos for the advocacy.
So why would I set it for exam when looking at the videos may change your whole approach to the case?
I believe we have to hold the exam, Your Honor, now that I have all the videos. This is not going to be a wait.
Okay, then why can't it be done in 12 days?
There are some difficulties in meeting with my client to review the videos because of some of the constrictions placed on his bond conditions, Your Honor. And even when discussing previously, when I reviewed.
What is the restriction? What is the bond restriction that's causing the delay?
Previously, I had asked about meeting at the U of M Public Library, but when I went there ahead of time, I noticed there were a bunch of children there present as well. So we're just meeting at a location in Washtenaw County to review the videos as proving some difficulty, Your Honor.
Well, here's what I'm going to do. I'm going to set it in 12 days. On the exam, we're going to do it then. Discovery is complete. Witness, the people would have their witnesses available the 27th. Preliminary examination in person, January 27th, 2026, 9 a.m. before Judge Washington. Bond will continue.
Thank you, Your Honor.
Court calls the case, People versus Austin Bryan.
Alex Jablowski for the People. Morning, Your Honor. Kevin Hager, hearing on behalf of Mr. Austin Bryan.
Well, did they have somebody? Who did they have? Oh, are they still there?
Yes, right there was the next one.
Which one? Who do you have? Brian, okay. That was my fault because I had to. It's a good way to get shot. All right. Your appearance, counsel.
Kevin Nagel on behalf of Mr. Bryan.
All right, your name? Austin Bryan. All right, what are we doing on this case?
Your Honor, I just met with the people today. I just subbed into this case. Apparently, there might be another charge that's being added to the current charges that we have. We'd ask for an adjournment on this matter. And I plan on discussing with the people possible resolutions with this.
So when will we know?
Judge, there's a note that there's a warrant request and I'll look at it.
I don't know. He doesn't know either.
Probable cause conference will be adjourned January 29th, 2026, 9 a.m.
Thank you, Judge.
Bond continued. Thank you.
Okay, looks like we're ready for part 3 in Judge McNally's court.
James Holmes.
It's not going to work.
Did it go through, Shane? I just left it down there and it hadn't gone through. How do we have Shane that went through? Did it go through?
Yeah, anytime he wants me to play it, it's. What do you want me to give him to?
Whatever you want him to play it, he's ready.
You could give it to that. Okay, recalling Kenneth James McKay Jr., 25B-149-883. Officer McParlin, your name again?
Officer McKay McParlin, Brownstown PD.
All right, start your video. Mr. McKay, your name again? All right, you're both still under oath. We're going to play the video, and you can tell me to stop it. Shane, will you stay there, please, and stop it but keep your voice up if you need me to stop it for any reason. And as the vehicle's traveling, feel free to tell me where you were, where the accident happened, any other important points you choose to bring up to the court. You can go ahead, I think, and start that now.
This is the day of the accident, the day it happened. We're going to do a video here. Here's the yield. I yielded for the person.
This was a different day, right?
This is the
officer
exact day. So the double yellow pens, right?
There are no swerve marks.
There's back out marks right there. Oh.
I saw where it ended.
So it's really hard without me being in control to show you things. At the very end of the video, you can see off the right shoulder, there's a wet tire mark on the pavement, and that's where I pulled off, where the officer had me pull off to go over. So that's how far down I was.
Officer, what kind of debris did you find on the scene?
I can't remember offhand, Your Honor. It's just minor debris. And like I said, I didn't get down and look at it and see if it was it was just minor. I can't really just describe it, Your Honor. If it pleases the court too, I have video footage as far as the body camera and stuff. Not with me. If we wanted to set another day, I have it. It was clear day where this accident occurred at.
Play this video again, Shane.
This is the day of the accident, the day it happened.
You need him to stop. Tell him stop.
We're going to do a video here. Here's the yield. I yielded for the person. Over here, the officer says he sees swerve marks. There are no swerve marks anywhere.
Stop, Shane.
So over there, looking at the screen to the left is where there are marks from somebody pulling out of the driveway and leaving. That may be the marks that he saw, but as you can see, there's clearly no debris anywhere at all. Because it was,
what time was the accident at?
I don't know the exact time.
What time was it, officer? What time did you respond? It says 2:38 p.m., right?
It was sometime in the early afternoon, Your Honor. I don't have that document in front of me today. It's one of the
What
only
time
days
did you drive here?
Oh, you can see the officer.
I'm asking you what time you drove, you created this video.
It was just after the officer relieved me from the scene. At the end of this video, you can see the officer's cruiser pulling away and the other vehicle parked down the road. So if you pause the video right before the end, that's where you can see my entire marks pulling away from where the officer had me pull away.
You want him to keep going on the video?
Yes.
Keep going, Shane, please. Pause. Back up a little bit if you can, Shane.
If you go to the end and 1 second from the end of the video.
1 second to the end of the video he wants, Shane.
There's the officer's cruiser.
Okay,
My pickup truck is in the distance. It's difficult to see there. It's on the left line.
that's the other vehicle involved?
That is correct. And if you go forward a little bit more and pause it, you can see my tire track. You can see the dot of the dashed line, first of all.
Go ahead and go a little bit further, but give me about a second up there.
Right there on the right is my tire track from leaving the scene to go to where the officer had me parked. Correct.
You talk about the one that's traveling, that's
That's correct.
right in front of the vehicle now. Oh, you mean that one over there, you're saying?
Yes, correct. Where I parked after the
And then, Your Honor, if I may, in that video, I'm trying to zoom in on that's still double yellow right there. Am I correct?
It is not.
I don't think so.
No, that's fine. But I went back and investigated as far as the marks here. And I remember seeing that there were the yaw marks going around the vehicle during the double yellow. So I can't really see on his video very much, but I did go back because the victim was very adamant about me going back where he said the accident occurred at, and there was swerve around marks going eastbound.
You want me to see anything else?
Oh no,
You want to what?
he said the victim. He replied, he commented that the other party was a victim.
I can't hear him, Your Honor.
That the other party was a victim. I said, I would like to be a victim.
All right, Mr. McKay, I can tell that you feel strongly about this. Well, you're going to have to appeal then, because I'm sorry. I think that this happened in an improper, there was improper lane use, because I think that I think you did it in double yellow lines. I don't want to argue with you. I've given everybody every opportunity. He went back. He said he saw where the tire marks were. He saw some debris there. The victim pointed it out. I'm sorry. I find you responsible as charged. All you have to do, you drive what? You don't have a CDL, or do you?
It does.
We got a chauffeur's license, right? Officer, I'm going to give him his choice. If you have an objection, you tell me.
Yep, I'm always willing to drop it down, Your Honor, but you can go ahead, sir.
If you want to plead to impeding, I'll take your plea. It'll be done. If you want to appeal, no problem. Then I'm going to keep this judgment in effect. You'll appeal it. You'll take it to the other judge. Maybe she'll agree with you. It's up to you. It depends if it's a wise guy question, but go ahead. Okay. I'm not going to revisit what my decision was. I want to give you a chance to appeal it. I can tell you feel strongly. Sometimes we think we're right and we're not. I'm doing what I think is right. I might be wrong. I've never said I'm right every time. I'll either let you plead to impeding, in which case you're forfeiting any right to appeal, or you can go down the hall, pay the $195, tell them you want to appeal. That will act as a bond, and you can go in front of the other judge.
Okay.
Okay. So you go down the hall. Heather, make sure that they set up an appeal on a formal $195. Good luck to you. You're welcome.
That guy just does not want to drop it. I'm still not completely clear on exactly how he is a quote unquote professional driver. Because he was asked if he had a CDL, he was asked if he had a chauffeur's license, and I didn't hear a clear reply. If you heard something, let me know in the chat, but I think that's just words. Let's change it up a little bit. I'm going to put us in the Wayback Machine and go to the Louisiana Pardon Board. This was actually from a couple of days ago, but I found it to be kind of an interesting hearing, and I've been holding it for you guys. So let's... Professional burrito chauffeur. Very funny, Charles. Anyways, let's pull this up and watch it and see what we think.
Case, Miss Francis, would you introduce yourself? Tell us your name and DOC number. Y'all are on mute, I believe.
Dana Francis, 458-021.
All right. Let me acknowledge the guests that we have, and then we'll get started with our process. So we have in favor, we have the Parole Project, Mr. Kerry Myers. He'll be speaking at the appropriate time. Also speaking is Deborah Sharkey, the chaplain for the Department of Corrections, or with the Department of Corrections, and then Deidre Thomas with RISE. You do have counsel this morning, so I'd like to ask your counsel to please introduce yourself for the record.
Good morning, Anna Rose Grodell, staff attorney of the Parole Project here on behalf of Ms. Dana Francis.
Thank you. We have also with us Beverly Baker, your mother, your aunt Pamela Francis, Stephanie King, a friend, Reagan Tingle, a friend, with the Parole Project, Dimitrisi, I'm sorry, I have a hard time with that name. Moore, Christy Sheremy, Sabrina Monaco, Kim Robinson with RISE, and Jan Waters also with the Parole Project.
Just to interrupt while they introduce people real quick, I will likely want to discuss this one in the 4th hour. So form your thoughts, and if we have time, we'll definitely go here in hour 4 during overtime.
As the employee. We do have opposition who are here with us on Zoom. We have the victim's son, Jonathan Hester, and the victim's daughter, Letitia Hester, and both of those will be speaking at the appropriate time. First, let me just read some identifying information into the record, then I'm going to turn it over to Mr. Tillis. Your case has been assigned to him. So, Ms. Francis, you're classified as a second felony offender. You're currently serving a 30-year sentence. You were sentenced in East Baton Rouge Parish in September 2002 for forgery. You received a probated sentence that was revoked in 2005 for a new felony conviction. And you were sentenced in April of 2005 for attempted second-degree murder. You received a 30-year sentence. The parole eligibility date is tomorrow, your birthday. You have a good time date, February 24th, 2028. Is that information correct?
Yes, ma'am.
All right, Mr. Tillis.
Good morning, Ms. Francis. How are you?
Good morning, I'm fine.
Good. Tell us, in your own words, what did you do and what caused you to be where you are today?
First, I would like to apologize to the family for the pain that I may cause today on top of the pain that I've caused, because I made the decision to shoot Miss Caraway, seriously harming her, and for that, I'm truly sorry. I was a 22-year-old woman staying with my cousin, sleeping on her couch, working at Microtel because I was on probation. On November 18th, I received a phone call informing me that I had lost my job. And November 19th, I took a cab to the job with the intentions of asking Ms. Caraway for my job. And upon me asking her, I became so overwhelmed with emotions of fear and anger and desperation. I shot Ms. Caraway. And I fled the scene out of shock and fear, but immediately I was so remorseful and regret, I contacted the police confessing to the crime of shooting Miss Caraway.
Okay. Warden, do you have any comments about her?
Yes, Miss Dana is one of our minimum security inmates. She actually works at the headquarters, DOC headquarters office, and she's been working since actually LCIW took over working at headquarters. So she's been a long-term inmate working up there, which is a trusted position. We always get glowing remarks from all of the individuals that work at headquarters that she works with. Along with that job, Miss Dana actually is a mentor in our reentry court dorm. So she mentors those individuals who were sentenced to reentry court and facilitates different groups either in our cell block or in the reentry dormitory or housing unit. I think probably one of the biggest accomplishments Miss Dana had received was yesterday. She actually graduated with her bachelor's degree in seminary. So I know Dr. Sharkey will probably talk about that, but don't want to speak for Dana, but I think that was an exciting day for her yesterday. But we don't have any trouble with Dana. She really helps out where we need her to, and she stays quite busy with her job, her studies, and mentoring inmates here at LCIW.
Thank you so much. Thank you. I guess now we'll hear from Louisiana Parole Project. Mr. Myers?
Yes, good morning. Kerry Myers with Louisiana Parole Project. We're here to let the board know we've accepted Dana Francis as a client in our program. Our plan for Dana is to provide long-term transitional housing, assist her with employment opportunities, ensure that she receives all the necessary evaluations, mental health, substance abuse, and abide by those plans, any recommendations that our social workers may have for her. Dana is completely remorseful for her actions. She didn't make no excuses for her actions. The difference is the now almost 45-year-old Dana has now learned the skills and has the skills through the work that she's done there to cope with the things that life has thrown at her before and in the future. Dana has a good time release date in early 2028. This is an opportunity at her age with the skills and she has learned both vocational and social skills she's learned while incarcerated. This is an excellent time that Dana is not only employable, she shows her willingness, besides the fact that she's gone to school, she works at headquarters, she gives back community as a reentry court mentor, something that is totally voluntary on her part because she wants to give back. She's very trusted. We would just ask this board to consider the fact the work that she's done, a degree in NOBTS, also attended Ashland University, also has vocational certifications, also does community service. Dana is not the 22-year-old socially ill-equipped person who made the decision to fire that gun that day. Dana can never take that back, but Dana has done the hard work, and we will support Dana on a long-term basis. So we'd ask this board to consider that today.
Thank you so much, Mr. Myers. Deborah Sharkley?
Sharkey.
Sharkey. Sorry.
Good morning. I am the Director of Chaplaincy Services for the Department of Corrections, as well as serve as the Director of the New Orleans Baptist Theological Seminary Extension Center at LCIW. And I've known Dana Francis since 2010. Over the past 15 years, I have witnessed a remarkable transformation in her life. Since Dana has been incarcerated, she has shown consistent dedication to her personal growth and faith and service. She did complete her bachelor's degree, and she actually completed the requirements for that degree in 2024, but we just had our commencement service yesterday, and it was a great time to celebrate what those women have accomplished. Dana has served as a peer minister, mentoring other women and providing leadership and encouragement across the whole facility. She oversees our faith-based recovery programs. That's Celebrate Recovery Inside and Life's Healing Choices. She helps women work through their trauma and their addiction. And she also teaches our pre-seminary class, Onesimus. She facilitates a helpful program called Courage for My Life. And she leads the faith-based classes in our lockdown units. and also makes regular rounds in the infirmary and assisted living areas. Her ministry offers comfort and support to the women who are sick, aging, and isolated. Dana also serves on the Department of Corrections Faith-Based Advisory Council. This is she is just one of 16 inmates throughout the whole state, male and female, that were chosen to serve on this board. Dana does have some CTE vocational skills that were alluded to, but one of them in culinary arts, she likes to use in ministry to help encourage people. So what she does is she will make little snacks and things like that to build community in the dorm among the other inmates. And she often volunteers to work in the kitchen when there's a special event, even though that's not her job classification. So over the years, I have seen Dana take full responsibility for her past. I've spoken to her at length about that, and she makes no excuses. She is dedicated to continuing to grow in her faith and in leadership. She is compassionate and humble and consistently demonstrates integrity and accountability. Her life truly is a testimony to the power of God and what it means to walk with Him daily, surrendering to His will in her life. And I thank you for your time and consideration.
Thank you so much. Ms. Deidre Thomas. Did I say that right?
Yes, you got it on the nail.
Thank you.
Hi, I'm Deidre Thomas. I'm paralegal at the Promise for Justice Initiative. I had the opportunity to meet Dana as a colleague at the Louisiana Correctional Institute of Women. At the time, I was a leader within the community, but I met a leader within the community that taught me how to be even a better leader. When I met Dana, Dana was the most humble woman that I met at LCIW. In that process, Dana has endlessly gone forward to help women in the community, whether they needed a word of encouragement, whether they were dealing with areas that they didn't want to cope with while they were on the inside. Dana helped me to see me at a different level. I stand before you today as a direct result of the board allowing opportunities for people that are incarcerated. Today, I ask that you provide that opportunity today. I'm an example. I strive because of women like Dana. I had an opportunity to be her colleague in disciplinary court. In that process, when I was released, I continued to progress and maintain contact with so many strong women like Dana so that I can continue to progress. Dana, the opportunities out there for her are just insurmountable. I may not be able to offer a job to Dana today, but I would offer her and even want her to live next to me. I would be willing to open my home to Dana. Dana mentored to me, even though she does not have children. She mentored to me to mentor to my own son. She mentored to me when I dealt with depression. She mentored to me and so many people that are in this room because she learned who she is and the power that she has if she only tapped into it. Dana's relationship with God has blown me away. As her choir director, we had a chance to harmonize and we didn't know what harmony was. And I want the opportunity with so many ladies to operate continuously in harmony with Dana to help see her reach her full potential. Although I think there's more that I can learn from her, but as well as to be in undoubtable truth that women that leave from a carceral setting, and no matter what they've gone through, that they can be successful and that they have a gigantic group of people willing to embrace them and to see them remaining law-abiding citizens in the state of Louisiana or wherever they be. Thank you.
Thank you. I guess last we'll hear from her attorney.
Morning. I want to begin by acknowledging the serious harm in this case. Ms. Caraway was an innocent woman, a kind woman who gave Dana a chance and was gravely injured. Nothing Dana has done or could ever do will change that. Dana carries deep remorse and regret for the pain she caused the Caraway family, and she lives with the weight of that responsibility every day. Today, however, the question before this board is not whether harm occurred. It did. The question is whether Dana has taken responsibility, genuinely rehabilitated herself, and whether the woman she is now poses a risk to public safety. Based on her remarkable record over the last 22 years, we submit to you, she has done the work, she has sustained it over decades, and she is ready for successful release on parole. I'm about to offer the following context, not to excuse her actions, but to explain the circumstances that shaped a single devastating decision that stands in stark contrast to the rest of her life. Dana was 22 years old at the time of this offense. She entered adulthood without stability, safety, or support. Her childhood was marked by severe domestic violence, addiction, and abandonment. She recalls coming back from school into the abandoned home where her mother was living, unable to recognize her mother due to the broken bones, metal plates in her body, and staples in her head as a result of being beaten while battling a decades-long addiction. Her father was entirely absent due to alcoholism, and in reviewing the trial transcript, he was quoted as saying, "I didn't want anything to do with her." She grew up in an area, in an environment where violence, addiction, and instability were constant. Despite that, Dana worked hard to avoid becoming a product of her environment. She worked multiple jobs. She put herself in school. She attended church, and she stayed away from the street life around her. But she was living on fragile footing. A prior poor decision, forging a check in a moment of desperation, left her with a conviction, probation, fees to pay, and no margin for error. At the same time, she experienced a series of profound personal losses. Her grandmother, the only person who raised her and who she felt loved her, rejected her because of her sexuality. Dana had also just ended the only long-term relationship she had ever known. She had unstable housing, no transportation, and was struggling in isolation. The job she held at Microtel was not just employment, it was her lifeline. When Dana received a call that she had been fired, she didn't just hear that she had lost a job. She experienced that as the end to the only remaining support in her life. That moment triggered a lifetime of abandonment, rejection, and unaddressed trauma. It was in that emotional collapse she made the only violent decision in her life, one that had grave consequences that she is deeply sorry for. What I am here to highlight is what Dana did next and what she has done every day since. Dana almost immediately turned herself in, accepted responsibility, confessed to her crimes, and pled guilty. She didn't minimize her conduct, she never shifted blame, and over the last 22 years, she has done exactly what this system is designed to encourage: rehabilitation, accountability, service, and transformation. Her record speaks to who she is today. Driven by her remorse and her self-insight, she has deeply engaged in therapeutic programming, completing every class and opportunity that has been available to her. including multiple rounds of anger management, stress management, depression focus, and trauma healing. She understands the root causes of her behavior, particularly her rejection trauma and her emotional regulation skills, and has demonstrated sustained emotional stability for years. Dana has relentlessly pursued education. She's completed multiple advanced degree programs, including, as you heard, her most recent one, she graduated from yesterday. One only need to glance at her record to see the extraordinary amount of work she has done to break the generational cycles in her family. The Department of Corrections has repeatedly entrusted Dana with leadership roles. She's been selected to facilitate Celebrate Recovery and Life's Healing Choices, supporting other women in their rehabilitation. Most notably, she is the only offender selected and certified to teach the Moral Compass class. She mentors the mentors. She teaches them skills like decision-making, conflict resolution, and ethics. This reflects the level of trust placed in Dana. She improves every environment she's in. She contributes to safety and rehabilitation in her mentorship, in her modeling of accountability, in her reinforcing the values that this system seeks to instill. For the past several years, she's worked here at headquarters in the Adult Services Department. Staff consistently describe her as honest, sincere, and exceptionally hardworking. One staff member told me I would have no issue at all with her living next door to me. That is public safety. I have been truly moved by the overwhelming support for her among staff and administrators alike. On release, Dana will receive long-term comprehensive reentry support through the Louisiana Parole Project. She will be released into structure, supervision, continuity of care, stability, and a huge support network. She has built meaningful pro-social relationships within her prison community, here at the Department of Corrections, and now with her family. Her mother, who's with her today, is now in recovery and facing her second battle with lung cancer. If parole is denied today, Dana will not be reheard for another 5 years, time she may not have with her ailing mother. Granting parole in this case aligns with the goals of this board. Dana is exactly the person parole is designed for. Someone who has taken responsibility, transformed herself, poses a low risk, and is ready for reintegration to continue the service and the transformation from inside to here. She is not the same person she was at 22. She is a disciplined, self-aware, intelligent, hardworking woman who has done everything in her power to ensure nothing like this ever happens again. For these reasons, we respectfully request granting parole in this case is not only appropriate, but consistent with the goals of this system and the interests of public safety. And so we ask, please grant Dana the opportunity to continue to serve the remainder of her sentence on parole under supervision. Thank you.
Thank you. Thank you so much. We have some people in opposition. And that is that concerns.
No, I'll just, no, we'll just include these in the record.
Okay, Mr. Hester?
Yes, sir.
Go ahead and tell us what you would like to tell us, please.
All right. I'm going to let my wife go first, if that's okay.
Sure.
Yeah, I just want to clarify, I'm not Cindy Caraway's daughter. I'm her daughter-in-law. Her daughter was trying to get on here, but was unsuccessful in being able to be let in. She didn't want to speak, but she did want to be present and noted that she is also in opposition. I want to start off by showing you, because she can't be here today, because Cindy Caraway passed away in 2020 due to the mental illness that she has suffered from this heinous act, this decision that Dana decided to do. From that day forward, while we say it's attempted murder, actually on that day, she did kill Cindy Caraway. And this is who Cindy Caraway is, or was. And I want y'all to see her face and to remember that. Because my children never got to know their grandmother prior to this incident. She was never the same from that day forward. She didn't smile like she used to. She would spend days and awake because she couldn't fall asleep, because when she fell asleep, nightmares came. She was distant. She was a shell of the person that she used to be. My kids, my sister-in-law's kids, never got to really know who she was. And she battled mental health until her very last breath when she took her life because she couldn't do it anymore. We sit here and I'm listening to everyone say about how Dana has taken accountability. I heard her say she's sorry today. That's all I heard. I heard her talking about herself just like she's always done. She was selfish. On that day, she was thinking about herself, and she downplayed it when she talked. And she said that she was fired. According to Miss Cindy, she wasn't fired. She asked Dana to come in and have a talk with her. And let's just say she was fired. You bring a gun with you to talk about being fired? Who does that? That's not somebody that went there with the intention of talking. That's somebody who went there with the intention of an action. Her intention was to shoot her. You don't bring a gun to have a talk. And while I hear everybody talk about how she's found God, I am so happy that she has, because she needed God. And I am so happy for that. That does not excuse what she did on that day and the punishment that she should have to have for that crime. God doesn't say just because you found me means that you don't have a punishment. When I punish my kid, I don't let them off early because they've made some good choices. And then we can talk about that as well. We can talk about how they said for 22 years, she's been this amazing role model. Well, records that I have received, 38 pages of it, say differently. And we can talk about those. In 2009, she was in trouble for self-mutilation. 2012, fighting. 2012, a loud argument dispute. 2014, defiance. 2012 and 2014, contraband. Theft in 2012. Aggravated disobedience in 2006, 2009, and 2015. Property destruction in 2012. Threatening behavior in 2013. She was in an unauthorized area twice in 2006. She had disobedience in 2007, twice in 2009 and 2012. And then my personal favorite, aggravated sexual offense in 2018. That does not sound like a role model the entire 22 years that she's been in prison. That sounds like somebody that was still actively not making good choices. And we're supposed to trust that she goes into parole. What if she gets in trouble again? What happened the last time she thought she was fired when she was on probation or parole? What did she choose to do? She chose to get a gun, call a cab, have the cab bring her to Microtel Inn, get out of that cab with a gun, ask the cab driver to wait for her, walk into Microtel, confront Miss Cindy and other employees in the washing area where they wash the towels and stuff, pull out the gun and point it at her head. Miss Cindy, terrified, walks out the door and takes off running down the hall. And Dana shoots her, takes the gun, puts it back in whatever she had it in, walks to the cab, tells him to bring her back to her home, where she gets out, brings that gun and hides it underneath the mattress of a baby carriage or something to that nature. She didn't turn herself in. They found her because she stiffed the cab driver and he called and reported it. What of that is fair? What of that? Like, what happens if she gets in trouble this time? I want to believe that God has made a big change in her, and I hope that he did. But that doesn't take away what she did and the fact that she should serve every single minute of her sentence, because the truth is, Miss Cindy served a life sentence with no possibility of parole. Her family has served a life sentence. We have to go each day without her here because of what Dana chose to do on that day over a stupid job. And Dana didn't apologize to all the other people it affected. Of course, it affected Miss Cindy and her family. But what about the people, the other coworkers that stood there and watched her shoot someone? What about the people that were at that hotel that heard gunshots and were probably terrified for their lives, not knowing what was going on? And all Dana was worried about was herself. And when I hear her sit here and ask for parole and all the things that she's done to make herself better, all I hear is selfishness. It's still about her. If she was truly sorry, she wouldn't put us through this again. She would take her punishment. And that would be it. If you're sorry, that's how you show you're sorry.
Thank you. Thank you.
Okay. So, look, I'm all for turning your life around, and doing what you're supposed to do. But we all have problems in life that we deal with. Bringing a gun to shoot someone because you thought you were getting fired and you're going to have to go back to jail is not good. That day she got when she found guilty of second-degree murder. No, she committed murder. It was a slow burn. For 20-something years, I've had to watch my mom, who was the most loving, would give everybody a second chance, would be the greatest, give you shirt off their back, deteriorate in front of my eyes. We go back and watch home movies, and you can see the drastic difference from the day she was before and to the day she was shot. And life has never been the same. We talked many nights about nightmares. She would stay up days at a time because she would just have nightmares about Dana putting a gun to her head and putting the gun to my mom's face that day and telling her she's going to shoot her. My mom runs away and you cowardly shoot her in the back, full intent to kill her, because nobody, if it isn't premeditated, nobody has the cab wait. Nobody brings a gun. Nobody hides the gun in her carriage. When they arrested Dana, she was smiling the whole time. Just like, oh, great. We go to court the day for sentencing. She just tells us basically, it's done. Let me live my life. Well, little did she know the domino effect she created. And they sit here, it's like they're just praising how great she is. Like, she did not murder somebody she murdered somebody. My mom. I'm happy your mom's there, and I'm sorry she's doing not well with her health and stuff. But my mom's not here because you decided you were going to take her life over a minimum wage job. To this day, I still see your face in that smile when they're arresting you.
Mr. Hester, would you address your remarks to the board?
Yes, ma'am. I still see her smile in her face that day they arrested her. The day we're sitting in court and my mom sitting there and just, you could tell she was so nervous. She threw up constantly that day because her biggest fear was she's going to have to see the person attempted to take her life, took her life that day. And to have that audacity to turn and tell the people, basically, get over it. Let me live my life. I'm all for turning your life around, rehabilitating. But we come from a world where if you do your crime, you should do your time. After the 30 years, so be it. But I have to tell my kids every day, when we watch videos and stuff, why did Mama change? Why is Mama like this now? I said, because someone decided they were going to play judge and executioner and decided to take her life. I can't tell people that my mom took her own life because that's not their knowledge. But I just had to tell people, oh, she was sick. But yeah, she was mentally sick because somebody decided they were going to take her life over a minimum wage job. Like, I'm not trying to be out of place. I apologize for my tone, but this is heartbreaking. We were going to do this a couple of years ago, right after she died, and we're trying to figure things out, but she got in trouble, so she couldn't get paroled. So to praise her and preach her for, oh, she's been a model citizen, man, we have a list. Like, we've been keeping up with everything. And who's to say she gets done and she doesn't come and retaliate at somebody else over a job? Like my wife said, if you get fired. If you do the crime, you should do the time. That's plain and simple. That's how the rule books are written. You're sentenced to 30 years. If you're good all 30 years or 25 years, you can get out of it. Great. She wasn't good. She started, oh, I'm sorry for what I did to that person said, I'm sorry what they did to their family. That's the first time. And I'm asking you, as someone who is a father, a son who misses their mom every day, would give anything to have a conversation with her, who can't still to this day delete her number from his phone. Just please do the right thing and make her serve her time. That's all I ask.
Thank you.
Hold on, one last thing. My sister and my wife are both battling breast cancer. Well, my sister is, my wife, we're dealing with that. My mom should be here today sitting with her daughter while she battles this cancer. But no, she has to go at it alone. So I'm asking you the last thing, please do the right thing and make her serve her time. Thank you.
Thank you. Thank you. Is that all of the the call for executive session, please?
Yeah, let me ask a couple questions. And then, okay. Where did you get the gun from?
I found it and I had it because of the area that I stayed in, because it was high crime and high violence. I kept it for protection because I stayed with my cousin, and we were the only female, and I would have to catch the bus early in the morning and it would be dark.
Okay. So you found it, you didn't buy it or get it?
No, sir.
From a friend or anything? Okay.
No, sir.
All right. I have no further questions.
I was going to ask the same question. I think there was something in the record that said you actually went and sought out the gun.
No, ma'am.
Okay. So I do want to, well, congratulations on your your graduation and your educational achievement. I wanted to ask you a couple of things. We heard the Hester's, Ms. Caraway's family talk about your conduct record.
Yes, ma'am.
And, you know, what I have to agree with some of it is concerning, but it seems like things changed in 2016, started to change rather. And that's when you seem to be more focused. What was it that clicked in you?
Doing that
conduct record, at least. That's when things started to change.
They started to change because I knew I had it to change. And it's true, God did change me. And it was right before my mom had really got diagnosed, and I knew that I had to change. And the things that I had done, that wasn't me.
You mean the things, what things? Explain that statement.
The reports like the unauthorized area, the defiance and the aggravated disobedience. Because I was raised and I am a person of respect. I am a person of integrity.
So I do notice you took a couple of victims programs. What did you get out of that?
When I took Victims Impact, I learned that I learned how I really affected the family mentally, physically, and psychologically. I learned that I affected my family, but even more so those that were around me that wasn't directly affected, but they were still affected by my poor choice.
So I'm just trying to get in my head as to, you know, why did you pull the gun out on Miss Caraway, Miss Cynthia? What was going through her head? And how is that?
During that time of my life, I had suffered so much rejection, and it was mainly due to my mother's drug addiction for 31 years, my father's alcohol problem. And I had just felt like so much had been taken from me. And I went that day with the intentions of begging for my job. And I just became so overwhelmed with anger and just feeling like the only person who was really giving me a chance was now rejecting me. And it was like I lost my mind, like I was out my body, like I committed a crime that I would have never done if I was in my right mind. I wasn't a violent person, and I'm not a violent person now. So coming to prison, I was determined not to be the person who fell prey to violence through rejection, where I worked on myself, where I took anger management multiple times. I learned how to deal with conflicts, and I learned how to find positive resolution. I developed coping skills where difficulties and challenges, they don't govern my emotions, they don't govern my life. And then I've developed a support network of leaders and mentors who've encouraged me and motivated me to be honest, to live in integrity. Which in turn, through those things, I've learned how to mentor other women and to show them how to deal with the struggles I had as a child myself.
Okay, thank you. Mr. Tillis has made a motion for executive session.
A second.
We have a second by Mr. Freeman. Without objection, we're going to convene executive session to discuss confidential matters. It's 10:39. We'll be right back.
They will sort of be right back. So I'm going to leave it there for right now. And in the fourth hour, we will go back. We will see what their decision is, and we will discuss this just a little bit. So stick around, because on the docket for TCF Overtime, I have discussion on this, as well as discussion on Hoarder Man and anything else that might come up. So be sure to join me there. We don't go here often, but it's always a good time. At least I think it is. Commonwealth of Kentucky, Judge David Williams.
It's now been moved over into the Supreme Court District with Bowling Green and Glasgow, and he was going to come down here today. So all of you are welcome. We'll take a brief pause at 11 and let him introduce himself here. He's going to come and make himself welcome in Monroe County. Are you Catherine Carmichael?
Yes, sir.
You were born in 1982?
92.
92?
Yes, sir.
Yeah. The last 4
Yes, sir.
You have an attorney here today?
No, sir.
What's the deal here? Can you not afford attorney or?
No, I can. I was waiting to be arranged so I could start looking and kind of figuring out where I needed to go from there as far as hiring it.
Yeah. Next time if you ever get indicted again, it's good to start figuring out before you come up here. For the purpose of arraignment, I'm going to let the Public Advocacy Office stand in. You have a right to remain silent. If you have any questions, you can step us back and ask her, okay? The grand jury of Monroe County has returned an indictment charging you with possession of controlled substance in the first degree, third or greater offense, possession of marijuana, possession of drug paraphernalia, tampering with physical evidence, being a persistent felony offender. You understand those charges?
Yes, sir.
Counselor, you acknowledge the identity of Ms. Carmichael, receipt of the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
I'm signing a reciprocal discovery order. I will let when you get are you going to get a private attorney, you think?
Yeah.
Okay, well, you need the private attorney to contact the Commonwealth Attorney's Office to get this discovery information about your case.
Okay.
And you need to be present with your attorney on February the 6th here at 9 a.m. for negotiations, and your next court date is February the 19th. Okay? You can just give her the indictments if you want to. Great. Thank you. Yeah. Jonathan Clark. Commonwealth versus Jonathan Clark. Now there's an active warrant out for Mr. Clark. Is that correct? He's been served this morning. Did you take him into custody or?
No, he's served.
Okay, that's okay. Mr. Clark, were you born in 1974?
Yes, sir.
Last four digits. We're here on 25 CR 0076 for arraignment. Do you have an attorney?
No, I don't. I'm in talks with one, but it ain't guaranteed yet.
Okay, well, I'll ask Public Advocacy to stand in for the purpose of your arraignment, okay? Now, you think you can afford an attorney or yet?
It depends on how much they want.
Well, that's always true. If it's $1 million, you probably can't afford it. $10, probably get Mr. Carter for $10. You get in Mr. Carter for $10? Well, you've lost him for 10. I guess it's.
I probably can't.
The problem you're gonna have, Your Honor, is Mr. Carmichael, Mr. Clark, and William Underwood are all co-defendants.
Yeah, you're gonna have conflict.
They're coming here and they say they're gonna give them attorneys, and if they don't get one, then DPA is probably gonna get conflict counsel.
Yeah, well, I'm going ahead and have you fill out an affidavit here, for Public Advocacy to see if you're qualified to get conflict counsel going. You have right to remain silent. The grand jury of, Monroe County's returned an indictment charging you with possession of controlled substance, first degree, third or greater offense, possession of marijuana, possession of drug paraphernalia, tampering with physical evidence, being a persistent felon offender. You understand those charges?
Yes, sir.
Counselor, do you acknowledge the receipt of the indictment, the identity of your client, waive formal reading and arraignment, enter plea of not guilty, reserving all
Yes, sir.
pretrial motions? I'm signing a reciprocal discovery order here. Requires them to do that. You take a seat here somewhere when we finish with you, and he'll do an affidavit to see if I can permanently appoint Public Advocacy to represent you. You be here on February the 6th at 9 a.m. for negotiation. And if you don't qualify for Public Advocate, you need to have a lawyer here that day. And then on the 19th, you'll need to be back here. So the 6th for negotiation, 19th the next court date. Okay?
While we wait for the next contestant, reminder, sidebar tonight, 8 p.m. Eastern, 5 p.m. Pacific. You need to join us for sidebar because the audience is in control. You put in the chat what you want us to talk about, and that's what we're going to talk about tonight, so it should be fun. As well, channel members, reminder, you can join me live during the 4th hour, which we're, about 25 minutes or so away from that. There is a link in the Discord in the member announcements, and sidebar channel members, there's a link in our private chat for you guys as well.
Morning, Judge.
Morning.
Judge, I don't know if he was transported from the facility. Which facility was he in?
I don't know. Probation parole sent him to long-term rehab.
Yeah, I think we sent him to the healing place. Yeah. And I had spoken with Mr. Stockton. If we can set this over to the February date, I attended the conference to try to negotiate, but we can set it over one date.
Yeah, one day, if he don't enter play next time, we'll be getting a trial.
What's he charged with?
He's charged with trafficking. The hangup is he's got a 20-year sentence from a jury trial and still got 12 years left on his parole. So I don't anticipate anything other than a trial, because if he's convicted, he's gonna have to serve out. He's gonna have his parole revoked. And while all this was pending, I think the parole board or somebody sent him to long-term treatment. I don't know what happened. So,
How did he slip through us not getting him transported? Did you not get him transported?
Judge, I didn't do a transport order. I just gotten in the case like Thursday of last week.
February the 6th for negotiation, February 19th.
maybe Mr. Garrett can make arrangements to have his client present.
Okay.
Joshua Pettigo. What kind of bond let's wait just a second. What kind of bond did I set on Mr. Jones? I don't really know how I've got somebody out loose that's got 12 or 13 years on the shelf and I got him loose on a bond. What kind of bond?
$20,000 private registry.
And he made that? Well, we'll revisit that
He's
next.
been on that bond since September 26th.
Yeah, he first had public advocate. He's just kind of been playing the system and delaying the case, but it's not gonna be delayed much longer.
Okay. You're Joshua Pettigo?
Yes.
Good morning. You're on 25 CR 0073. Were you born in 1986?
Yes.
Last four digits.
Yes.
Do you have an attorney?
Not yet. I'm gonna hire one though. I didn't know I needed one today. I thought this was where you would ask me.
For the purpose of arraignment, I'm gonna let public advocates stay in. You have a right to remain silent. The grand jury of Monroe County has charged you with trafficking controlled substance first degree, possession of controlled substance in the second degree, and possession of controlled substance not in the original container. You understand those charges? Counselor, do you acknowledge the identity of Mr. Pettigo, the fact that you've received indictments, waived formal reading and arraignment, enter plea of not guilty for serving all pretrial motions?
Yes, Your Honor.
Mr. Pettigo, I'm signing a reciprocal discovery order that requires the Commonwealth to provide information you concerning preparation of your case. You be with an attorney here February the 6th at 9 a.m. for negotiation. February 19th is your next court appearance. You need to have attorneys there. I'm not going to tear you with this.
Talk to Nick as soon as I get done here.
Okay, that'll be fine. Thank you. Stay on the same bond. Rhonda Shinning. Catherine Carmichael qualifies for a public advocate. Yeah. Catherine Carmichael? Okay, well, I'll go ahead and appoint public advocate next time. I won't do it this time. I'll just keep the affidavit. Just put that affidavit in the file and I won't sign the order. Are you Rhonda Shinning? Is that how you say your last name?
Yes, sir.
Okay. This is 25 CR 0060. Were you born in 1976?
Yes.
Last four digits.
Yes, sir.
You're here for a pretrial conference today. You're represented by the Office of Public Advocacy. What do we have going on here?
We have a pretrial diversion, Your Honor.
Okay. Just been informed a motion has been tendered that says you wish to enter a plea today. Is that correct? Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person that we just identified in 25 CR 0060?
Yes, sir.
Is your judgment impaired today in
No,
any way?
sir.
Have you discussed the charges with your attorney, and are you satisfied with her advice?
Yes, sir.
You believe you're fully informed about the case. You reviewed the evidence. Is that
Yes, sir.
correct? You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept this plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury, right to be represented by counsel at your trial, the right to confront and cross-examine all witnesses called to testify against you, the right to fix evidence, the right to call witnesses in your favor and have process issued to compel their attendance. You have a right to appeal this matter to higher court if you lose, and a right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty charged against you. Understand it, by entering guilty plea today, you give up all those rights.
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept any recommendation. In the event I don't accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have a right to withdraw your plea of guilty and proceed to trial. Do you understand that?
Yes, sir.
I'm going to ask you some qualifying questions. Have you previously been diverted in the last 5 years?
No, sir.
Had any felonies in the past 10 years?
No, sir.
Are you currently on probation?
No, sir.
You understand if you complete the diversion program, the charges will be dismissed, pretrial diverted, and you can have them expunged. You understand that? But if
Yes,
you
sir.
don't successfully complete it and you're brought back in front of me and I revoke your pretrial diversion, schedule a sentencing hearing, you'll be a convicted felon and that could be used against you in the future. You understand that? Mr. Judd, are you presenting?
The Commonwealth agrees to dismiss possession of drug paraphernalia, which is a Class A misdemeanor. Upon the plea of guilty to possession of controlled substance, first degree methamphetamine, the defendant shall receive a sentence of 3 years pretrial diverted for 5 years supervised. The defendant shall receive credit for time served. The defendant shall be referred to the social service clinician and following any and all recommendations of the clinician. The defendant agrees to have any and all evidence above case forfeited and destroyed in a manner consistent with the laws of the Commonwealth of Kentucky. It is understood that this offer as made by the Commonwealth is not binding upon the Commonwealth until signed by his attorney. It's effective on that.
Is that what you agreed to?
Yes, sir.
Are you pleading guilty to the indictment as amended because you did commit the acts charged in the indictment?
Yes, sir.
Doing so of your own free will.
Yes, sir.
Your constitutional rights have explained it to us is still your desire to proceed with a plea and allow the court to fix your punishment within the range permitted by law. Is that correct?
Yes, sir.
Is that your signature on the motion and offer?
Yes, sir.
I'll accept the agreement, sign the diversion order. What's the court cost in this case? You need some time to pay that?
Yes, sir.
I'll just pay it $30 a month. The first payment due 30 days from today. That'll get you time to get on your feet a little bit, okay?
Yes, sir.
You need to meet with the probation parole officer right there. Robert Simpson. Commonwealth versus Robert Simpson, 24 AD, 24 CR rather, 0079. You are Robert Simpson?
Yes.
Born in 1991?
Yes, sir.
Last four digits. One, is that correct? Mr. Carter, have you had an opportunity to review the pre-sentence investigation report done by probation and parole?
Yes, sir.
Is it substantially correct?
Yes.
Mr. Carter, is there any reason this gentleman should not be sentenced?
No, Your Honor.
Or plead guilty to trafficking controlled substance, first degree, first offense, methamphetamine, the defendant shall receive a sentence of 5 years, probated for 5 years, shall receive credit for time served, shall have employment. Are you employed now?
Yes, sir.
Where?
Simpson Farm.
Okay. All evidence would be destroyed. Court costs $240. You need some time to pay the court costs. I'll let you pay it $30 a month. The first payment due 30 days from today, okay?
Thank you.
Need to meet with the probation parole officer. William Underwood.
All right, let's change it up a little bit. We'll head back up to Michigan, spend some time with Judge Simpson. He'll probably take us into the 4th hour.
I know.
I'm doing okay. What's your name?
James Holmes.
Was it cold up here? Is that why you had to put on your coat?
Oh, yeah, man.
Oh, okay. All right, I'm just checking. All right, what are we doing?
Your Honor, we're requesting a 2-week adjournment. I got the discovery yesterday, so I need to meet with Mr. Holmes, go through it and see where we're going to go.
Probable cause conference, February 5th, 2026, 9 a.m. Bound continue.
Thank you, Your Honor.
Court calls the case People versus John Brown.
Andrew Childers appearing on behalf of the people, Your Honor.
And Assistant Public Defender Natalie Pate with and on behalf of Mr. John Brown, who stands to my right. What's your name for the record, sir?
John Brown, how you doing, Your Honor?
I'm doing very well, Mr. Brown. The court has before it a plea form. That's what we're doing today.
That is correct, Your Honor.
He's going to plead guilty to an added count 2 of use of a controlled substance, that being fentanyl, a misdemeanor punishable by up to 1 year. Upon successful plea to that charge, count 1 would be dismissed. And the sentencing judge waiver box isn't checked, but
Oh, I'm sorry, Your Honor.
Did you
We
explain
did
all of
go
that to
over
her?
that. Yes,
All
we
right.
did go over that, Your Honor. My mistake for not checking that box.
all right, very well. Could I have him sworn?
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give be the truth, whole truth, and nothing but the truth? So you got it.
Yes, ma'am.
Lower your hand, state and spell your name.
John Brown.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of fentanyl. That is a misdemeanor punishable by up to 1 year incarceration and a $2,000 fine plus court costs. Do you understand that?
Yes, sir.
You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes, sir.
You understand that?
Yes.
All right. Still wish to plead guilty
Yes.
to that charge? How do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
All right. You signed an advice of rights form or went over one with your counsel?
Yes.
Any questions regarding any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of it.
Yes, Your Honor.
Are you on probation or parole?
I am on probation.
Were you on probation at the time of this offense?
No. Yes, I was.
You were? Okay, I do have to advise you then that your guilty plea in this case could be considered a violation of your probation. You understand?
Yes, I've spoken with my probation officer. She knows what's going on.
All right. I have to advise you that if it is considered a violation, that court could sentence you to the maximum allowable under that other charge. You understand that?
Yes, sir.
All right. And understanding that, you still wish to plead guilty to this charge?
Yes, Your Honor.
All right. Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
I am guilty.
January 24th, 2025, at the location of 49230 Michigan Avenue in Ypsilanti Township, Washington County, State of Michigan. Did you have fentanyl in your possession?
Yes.
Had you used it?
It was in pill form. I didn't at the time. I didn't know it was fentanyl, but yes, I did take one. Yes.
So you didn't know you had fentanyl in your possession?
It was in a Percocet form. I thought I had bought a Percocet pill.
So you didn't know what you were using was fentanyl?
Ignorant. Nope, didn't know.
But you knew, okay, but it was a Percocet you thought you were taking?
Yes, I knew it was illegal that I didn't have a prescription
You
for
did
it.
not have a prescription for it. And so you were in possession of a controlled substance that you shouldn't have been in possession of, correct?
Yes, sir.
All right, then there's a number of ways I can do it. Higher.
Yes, Your Honor, I would ask
Take
that take plea to the higher the
All right,
charge.
sir, if I accept your plea, I need to apprise you that if you commit misconduct as defined under Michigan court rules between the time of my acceptance of your plea and the time of your sentencing, the court would no longer be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that?
I understand, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And has the court complied with the court?
People are satisfied, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing will be
10 a.m. Washington.
February 12, 2026, 10 a.m. before Judge Washington.
Your Honor, may I address bond when appropriate?
I don't know if it's appropriate or not, but go ahead.
Thank you, Your Honor. It is my understanding, I was not the attorney at the last probable cause conference, but it is my understanding that Mr. Brown was remanded at the last hearing for a community corrections bond violation. It's my understanding he's been in jail a week on that violation, and the basis of it was 2 missed tests, as well as I believe a test that was positive for THC. I have spoken about this to my client. He of course admits to the bond violation. He did appear last week in court knowing that he was likely to be remanded on the bond violation. I do not believe him to be a flight risk. He does have a residence where he lives with his girlfriend and 4 children, ages 16, 14, 3, and 11 months in Taylor, Michigan. He further has full-time work doing cement and flooring. He's a finisher. He is asking if the court would consider reinstating his personal recognizance bond. He is willing to do anything that the court obviously orders. He understands he cannot have a single more missed test. To my understanding, his positive test didn't have anything else positive besides the THC. He's willing to go on tether. My client even told me he'd be willing to do house arrest. I advised him that is likely not the appropriate sanction the court would issue. However, he understands he's not to do substances. He needs to.
I'm not going to change his bond. What he's going to need to do is he's going to need to talk to the probation department there, and then in Judge Washington's good wisdom, decide to change his bond.
Understood, Your Honor.
Your Honor, first I understand you say you're not going to change my bond. I just want to apologize to the court.
You're still going to ask me? No.
Yeah, I just want to apologize to the court for my ignorance and not knowing that I was supposed to go over there. But I really need to get back to work. Like I'm down. I'm willing to go on tether, whatever. I just want to be able to get back to work. Right now, my girl's not working. I got 4 kids at home. Very, very high rent.
Okay, sir. What I've indicated, and your counsel knows how to get through to 14B. They can contact 14B, get you interviewed, and then get to Judge Washington to reset your bond. But at this point, I'm not changing your bond. Thank you.
Thank you, Your Honor.
Court calls case People versus Jaleesa Robinson.
Your Honor, Raymond Cook, the people. Your Honor, J. Grant Miller, P58658.
Ms. Robinson should be appearing via Zoom.
You have her. Lisa Robinson. So we don't have her checked in, is that? Warrant will issue bond 10,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Court does call the case People versus Edna Grima. Grima.
I'll have love to the people.
Good morning, Honor. Charlotte Stephan on behalf of Ms. Grina.
You take your hands out of your pockets. Whoa, I wasn't arresting you yet. Your name?
Edna Gurma.
All right.
Your Honor, we're asking for an adjournment of the probable cause conference. I was just appointed and I'm still obtaining discovery.
All right. February 5th, will that work for you?
Your Honor, I am out of town that day.
I can do the 29th if you think you can get everything by then, or I can do the 12th. Which would you prefer?
I would prefer the 29th, please, Your Honor.
29th.
Of what? January, so 2 weeks.
January 29th, 2026, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you.
Thank you.
Court does call the case for the people versus Bradley Potter.
Good morning, Your Honor. James Fifelsky on behalf of Mr. Potter on case ending in 5728.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Potter in case, and actually my case is ending in 5728. Mr. Fifelsky's ends in 1624. And Mr. Potter, can you please state your name for the record?
Bradley Earl Potter. Thank you, sir.
It's okay.
What are we doing?
Your Honor, we're asking for an adjournment. I am still in need of discovery. And I don't think we need much time, but that's the reason.
Discovery is complete on my case, Your Honor, but in an effort to track these cases, I would echo Mr. Fifelsky's request and then also request to address bond briefly.
Probable cause conference will be adjourned to January 29th, 2026, 9 a.m. Yes, as to
Thank you, Your Honor. As to bond, Your Honor, my client was picked up on this matter while he was in the hospital trying to receive treatment. They ran his name. They arrested him from there. Your Honor, these cases are relatively old. One's from 2020, one's from 2021. My client has been able to stay out of trouble in that time. Understanding the charges and the seriousness of them, my client does have a place that he can stay. He can stay right in Ann Arbor. He's willing to do GPS tether home confinement. He is disabled, Your Honor. He was also accepted into the home of no vision. He did access. He was accepted, as I stated. I understand that the court would rather go the order for inpatient treatment route, and I'm happy to do that, and I can get that in today if the court's unwilling to let him out otherwise.
response from the people.
I would object to any change. On my understanding is that, picked up on insurance was number to appeal back to 2021. I understand the age of the cases. But I also just briefly flipping through defendant's criminal history, see a multitude of RN convictions and 2 prior domestic violence third offense convictions, which causes me significant concern for the safety of the community and for the safety of the victim. Not to mention failure to approve that for 5 years.
Motion for bond reductions denied. Bond will continue.
Would the court allow inpatient treatment?
If there's no objection to that, I customarily sign inpatient treatment.
Thank you.
So,
No, thank you.
sent over, I'll sign off on it.
Thank you very much.
Or calls the case.
Okie dokie, friends. That is the end of 3 hours of court. It is now time for TCF overtime, where we can talk about some of the stuff that we saw today. So I've got 3 things that I wanted to go through. I've got Hoarder Man. I've got that pardon board where we need to see the end of it and then discuss it. And as well, I have some more data along the lines of what we've been talking about with stranger danger and kids and all of that. And honestly, I think I'm going to start there and give you guys the opportunity while I'm going through that to phone in, as they say, if you want. So again, channel members, if you go to the member announcements in the Discord server, there's a link there, and sidebar panel members, there's a link in our private chat if you'd like to join me to talk about Hoarder Man or the pardon board or anything else. But I'm going to lead off with some of this data. So we started this thought experiment a few days back, and it started with the idea of us moving the danger for our children from outdoors to indoors through the whole milk carton thing and then into the stranger danger. And at the same time, you had the rise of things like the internet and video gaming and stuff. So it gave kids things to do inside. And we ended up moving the danger from outdoors to in. The other day, we talked about where is your child more at risk? Is it from like walking home from school? Or is it from being online with access to direct messages? And we talked about that. But one of the things that we talked about in all of that was how often with children, if it's an in-person issue, it is more common that there's danger from an acquaintance than there is danger from a stranger. So I have some information on that so we can kind of further our understanding there a little bit. So this is stranger danger versus familiar danger. So child maltreatment. Now you can define that as neglect, physical abuse, a more personal kind of assault, things like that, but just group it under maltreatment, okay? As of 2023, that was the latest data, 76% of such incidences were perpetrated by parents. So just over 3 out of 4. When kids are sexually abused, it's usually by someone they know. The statistics there, 93% of victims under 18 knew the perpetrator. 59% were acquaintances, so people known to the family. 34% were actual family, but only 7% were actual strangers. So chew on that for a minute. So often with our children, the biggest piece of danger comes from those who are already around them, rather than the people that we fear outside of our circle. And we've closed ourselves so much in our communities, and we don't interact with people and whatnot of all of this fear. But the fear is just not as founded. If you look at the data, it's more common that they're going to have problems within the circle around them. So where did I leave off here? Even missing kids aren't usually a stranger danger snatch type of scenario. Most missing kids are actually runaways, statistically. Non-family abductions are less than 1% of cases, according to NCMEC, the National Center for Missing and Exploited Children. So 99% plus of cases, if it's not a runaway situation, it involves a family member taking the kid. So again, the danger is just not it's just not statistically from outside. And stranger danger is rarer, but when it hits, it definitely is probably, well, I say definitely is probably, way to contradict myself, Dan. It's probably the hardest hitting. So this was a kidnapping study from 1999, which is the most recent broad study I could find. And it said in its study that it found over the period it was studying, and I forget the exact period, but it was a period of a few years, it found 115 quote-unquote stereotypical kidnapping. So your stereotypical kidnapping is one done by a stranger. But in that same time frame, it found over 58,000 abductions related to family members. So it's not even close. But again, when it does happen, it hits hard because within, if you have an abduction and the child is murdered, 74% of it within the first 3 hours, 90% within the first 24. So if your child is taken by a stranger and you don't get on it like immediately and solve it, if it's going to go south, it's going to go south fast. So that's where like the milk cartons and stuff failed, as we talked about before. So there you go. Anyways, I just wanted to share that data with you because it expands upon what we were talking about before. But so often in this desire to protect our children and protect our families, we're making the wrong choices. We're not focusing where the real danger lies for them. You know, we're so worried about them being outside and getting around and learning their neighborhood and playing and being involved and all that kind of stuff that we've probably overexposed them to the bigger risks that they face. So just thought I'd share that with you because I found that to be fascinating data. And Ashley is here. What does Ashley want to talk about?
Hi.
Hi, Ashley. Do you have discussion on that, or
Yes.
were you looking for one of the other ones?
No, discussion on that actually, because those statistics are really frightening.
Yeah, aren't they?
I it's so much different than when I was young, and I know I'm still young, according to other people, but
You are very young.
even in the 90s, okay, back in the 90s,
I have a
early
daughter your age, Ashley.
the 90s, early 2000s. Then, even in that, even then, yeah, there was stranger danger. You had to be careful in communities, but it's not like it is now. We could still ride our bikes, have fun, go to a neighbor's house, things like that without any worry. But now these days, you have to, you know, it is kind of mesmerizing because even though we have these phones with us wherever we go, that it has the opposite effect. It seems that the more we are being tracked and the more in the digital age, seems like the more danger we're being put in on an everyday basis too. So I just wanted to bring that point up because it seems like the more electronics we are getting, it's shaping, yes, the kids staying indoors, playing video games and staying safe, yes, but that stranger danger thing, statistic that you said that more is happening from family members and people that that person knows is quite confound because we didn't even considered that when in the 90s and early 2000s. So it's,
Yeah, and it makes you wonder, I suppose, since we didn't even consider it then. You know, when we moved the kids off the street, did we change maybe the distribution of the danger? This just occurred to me.
Right.
And what I mean by that is, were these people who had these predilections because there wasn't the supply of them outside, are they now going to family members to fulfill their urges? I don't know.
And that's very possible too. I'm not sure.
Yeah, that might be part of the skew in the data. But as it stands right now, it's the family and friends that are the bigger risk.
I mean, something had to change, definitely. With more kids being home and being less susceptible to family members, I think that has also a hand in it as well. There's more online schooling than ever before as well. So kids are staying home more, and things of that nature. So yeah, I think it's the accessibility. There's more younger people staying home these days and being more accessible to by family members and other family members. uh it's awkward, right? With the family member and the other family members kind of, I don't want to say turn a blind eye, but they don't really know what to do in that situation because yeah, it's family. You wouldn't expect that from a family member. So that's also something to think about as well. There's multiple facets to this issue. Um, and yeah, I think we just skimmed the surface of it.
Yeah, I'm going to keep digging on it because the more I'm digging in, the more fascinated I am just by the breakdown of things. I mean, I'm saddened by it too. Don't get me wrong. There's just way too much of this stuff that goes on, but it's interesting how the breakdown of the data is happening, and where it shows isn't necessarily where our focus is. And that's what's so weird to me.
And also comparing the data maybe from maybe the early 2000s to now, that would be interesting to look at as well, just to see how that has morphed over time. And I believe COVID didn't help things either. I think people are still in that COVID culture or COVID society type thing. I don't think that's helped either in 2020.
No, though I will say that last thing I pulled up was 1999. So really, as the internet was just starting to really ramp itself up, it was 115 of the quote-unquote stereotypical kidnappings with 58,000 actual abductions by family.
Wow.
So even back then.
Even back then, but you just didn't hear about it.
Yeah. Now, how do they and I'm willing to bet that a lot of that 58,000 is custody dispute, because that's the most common kind of quote unquote abduction, is custody stuff.
Yeah.
Where you've got a parent who doesn't want to play nice.
Right.
But still, I mean, even back then the data was massively skewed in the one direction. So it's curiosity.
Wow. That's mind blowing, but
I know. All right. Well, I'm going to move on to the next topic.
That's all I have to say about that subject, but I just want to bring up some points that you had, because those statistics are not, they're frightening, to be honest, because you need to rely on those people to help you provide shelter and safety, and if you don't get that at home, where do you get that? It's awful.
Well, in a lot of cases, they just don't.
Yeah.
They don't get that.
And
That's
people
kind
are
of the bottom
wondering
line.
why society is like it is. Well, that's a big one right there, I think, that you mentioned.
How many times have I said it? It starts by building good families and good people.
Yep, exactly.
I'm not saying, I'm just saying, you know what I'm saying?
Yes. I'll let you go, Dan, but thank you for letting me
All right.
talk.
Oh, thank you. Hang out if you want for any of the other topics. Just
Oh,
raise
I
your
will.
hand if you want me to call you back in.
Yeah, I'll
right.
hang out.
Cool. Okie dokie. Let's talk about Hoarder Man for a minute. So I have lost track as to how much we've seen Hoarder Man on this channel. I think this was hearing 5, maybe. 5 sounds right, but to be honest, we've seen him so much I've lost track. And I don't know what you guys think, but I walked away from this hearing. Oh, I didn't walk away, did I? I sat here after the hearing, and I was very disappointed in Judge McNally. And honestly, I'm also disappointed in Woodhaven and how they're handling this as well. I don't understand, first off, why the city has allowed this to drag on for as long as it has. It just makes zero sense to me whatsoever, because most cities that I've experienced anyways aren't going to tolerate it for that long. They just aren't. Go to St. Joe County with Judge Middleton, and he's got a similar Hoarder Man case going on there. And as I recall, he was given a deadline, and after that, the city's just going to move in and they'll put a tax lien on his property. They'll clean it up and, they'll put a lien on it to pay for it. That makes sense to me that it should happen that way, but Woodhaven just keeps dragging its feet. And I'm disappointed in Judge McNally and how he's handling this, because he's coming across to me as an enabler, to be honest with you. This has been dragging on for so long, and we keep hearing from McNally, I don't know what to do with you. He's said that in the last several hearings. He keeps repeating it. I don't know what to do with you. I don't want to do this. I don't know what to do with you. I don't want to do this. You're making me do this. I don't want to do this. I don't know what to do with you. And yeah, he did put him in jail the one time for a few days. But he's allowing these excuses to just continue to set in my opinion, and it's becoming enabling for him, because I think he's under the impression, again, there was that one exception where he was jailed for a couple of days, but he's getting this message that it's okay to continue to drag his feet. And McNally said to me, or he said to him rather, that, well, I mean it this time. Next time you come in here, if it's not ready, things are going to happen. I don't believe him necessarily. And I like McNally a lot, but in this particular instance, I'm not believing what he's saying. I don't buy it. And I don't buy it because, again, we've been through this so many times now, and there's so little progress being made. And you've got the Good Samaritans who are lined up and ready to help this guy, and he's not taking advantage of it. There has to be something there that's more forceful, because the guy is just not going to get there on his own. And McNally softballed him today, or yesterday it was, we showed it today, but he softballed the whole thing in my opinion. And I think it just continues to enable him. It's the parent who counts to 3. but the child knows to just shut up at 2. And if the parent gets to 3, half the time they're not going to do anything anyways. You know, sometimes you have to take punitive measures that are swift. And I think that is what this guy needs, but it's just not happening. And maybe it would be easier on McNally if the city would actually take some sort of action, like so many other municipalities will, but they are not. They're just complaining about it for 25 years, which again is just another enabling factor. So you can let me know if you think differently, but I was disappointed in how that was handled, and I don't think it's going to be any better when we see him in March. And something tells me that it's not a slam dunk that McNally throws him in jail in March when it goes south, as we know that it will. Because it will. But I could very well be wrong. Ashley, tell me I'm wrong.
No, you're not wrong. In 9 years of in my previous workplace, I spent 9 years in more of the property management sector. And we had the same issue. We would have tenants that stayed in properties for so many years. And they got used to different things. I mean, we would hear excuses every month or so, and we wouldn't give in, not because we're mean people, but because we had to set that groundwork that if I give in to this person, they might come around and say, well, you did that last time. And that's kind of what I relate to Hoarder Man, because McNally's like gave in the first time and it's like, okay, this is your warning. And then he came back and kind of gave him a second warning, and so on and so forth. And now Hoarder Man expects that the judge will be lenient with them because he was lenient with them the other times through. And that, yeah, it's a slippery slope, for sure. Not saying that ground rule and that expectation the first or second time he came in. And now, yeah. And I know we're human, right? And judges are humans too. They want to be kind to people, and they want to help people any way they can. But sometimes helping people is not in the good of the situation, and I think that's what happened here for sure.
Yeah, McNally's behavior kind of reminds me back in the 80s. I think it was Gaddafi in Libya. He had the line of death, and he's like, "Cross this line, you die." And then the U.S. and other allies get up on the line, and then the line moves back. Cross this line, you die. Cross this line, you die. And then next thing you know, the line is at his front door. It's kind of the same thing. It's like hollow threats.
Yes. Yeah. And if you don't act on those threats, it tells that person, oh, he's not being serious. And it takes advantage of that person. And I hate when people do this, because I like to think of the good of other people before I think badly of them. But people will take advantage of that person's actions. They do every chance they can. And I've gotten burned so many times letting people do whatever they kind of want to do. You just can't. You have to set that ground rule, and you have to say your expectation, what the consequence of that expectation is. And if you don't follow upon it, you cannot set that expectation again.
Yep. No, exactly. We'll see what happens in March, but based on what I saw today, I don't buy that anything's going to change with that guy, because he's still full of excuses. And I don't buy that anything's going to change with McNally, because he's been relatively soft on this guy the whole way. And I don't get it, because he's so harsh on others. I don't know what it is about this guy.
Yeah, and the Woodhaven Township is another thing you were talking about them getting away for so long, and not taking action. That's puzzling for sure. I would think they would have a paper trail of them reaching out to him about, like with warnings and things, they should have taken action a long time ago as well. So it's the combination of the Woodhaven Township and the judge that's making this situation just awful.
I wonder if it wasn't difficult in the first place for whatever reason, and the mentality becomes, I'll just leave it for the next guy. And after 25 years, there's been several iterations of the next guy.
Well,
You know
yeah,
what I mean?
he's not a young chicken. But he did say that the person that he talked to before retired. I
Yeah.
did catch that part. So yeah, I'm sure that has something to do with it.
Yeah. It's people being lazy.
Yeah, definitely. And I hate to say this, but a lot of cities and townships in Georgia are especially lazy as well. So I cannot say specifically that they're lazy. I think all the government agencies are somewhat kind of the same with that
Yeah.
laziness factor. So I'm
No,
just
there's
saying.
truth there. Yeah.
But I think I totally agree with your point of them having to, they should step in and clean up the mess and then bill him for whatever they need to bill him for. I know it's not a thing in this township, but I think it should be a thing and something that they need to pass for sure.
Well, at this point, it's the cleanest way to handle it. But we lose content that way, so
I know, but it would save the judge brain cells and would save the township brain cells, and ultimately it would Horderman will not like that for sure.
No.
Because he doesn't want people to touch his stuff, and I totally understand that, but at the same time, if you are told to do something and you do not act upon it and don't get it done, you should expect consequences. And that would be part of those consequences that we were talking about before. So,
Yeah, you would think so. All right, what do you say we finish up this pardon parole board thing?
Yeah, I was not. You will have to fill me in on that because I was away for that time. So,
Okay.
you take it away,
Well,
Dan.
50,000 foot view for anybody who was away for that time. This was actually, I put us in the Wayback Machine for this. This was from 2 days ago. And this is a woman in front of the board who 20 some years ago was on probation for something. She worked at a microtel. She got a call that she was being fired. She went to the microtel, confronted her boss, shot her boss, but did not kill her. So it was like an attempted murder kind of thing.
Okay.
So during her time in prison, she has quote unquote reformed and been a model citizen. That's what the advocates for her, including a bunch of the the prison officials rather, were saying. She has found Jesus. She has become like a minister or a leader in ministry. She is got a degree, as I recall now. She's done all of these things, right? But then the victim's son and his son's wife get on, and they're incredibly emotional, and they've got a whole list of all of the offenses that she has had while she's been in prison. And supposedly her transformation started in 2016, but she still had issues in 2018, violations and stuff. So there's like two sides to what's going on here. You've got those on her side that are saying she's completely changed. You've got the victims going, no. And oh, by the way, the woman, it wasn't expressly said, but it sounds like a few years ago she committed suicide, the victim. Because they said that she died from all of the mental stress of it. So
I see.
So it implies that she committed suicide. So their argument is it wasn't an attempted murder, it was a murder.
No.
So that's what they're arguing. Again, very emotional, very compelling in their own way. But so that's kind of the two sides of all of this. And they went into executive session, and now we're going to figure out what they did in executive session. And then we'll talk about it.
Gotcha.
All right, everybody's caught up. Hang tight. Let's pull up that hearing and pick it up where we left off. Let's go there. All right, guys, here we go.
Right, I'll move to go back into regular session.
Second.
And second by Mr. Tillis, without objection, we're back in regular session. It is 10:45 a.m. And we are prepared to vote. Mr. Tillis will be voting first.
Ms. Francis, I commend you for the positive things you've done. And I really am sorry that the family for their loss. I am. And I'm not going to drag this out. My vote today is going to be to grant to the Louisiana Parole Project.
Mr. Freeman.
Okay, I also want to commend you on everything you've done. One thing I do want to note is that you have a good time date in 2 years, so it's not actually 5 years. So regardless of what we do today, you get out in 2 years. But that family's still suffering, and it's tough. And I do realize it was totally premeditated. So my vote today is going to be to deny victim opposition and law enforcement opposition.
Yeah, there is very strong opposition in the record, Dana, from the prosecutor and law enforcement. You heard from the victim today. I agree also. Some of the things that you said to us today don't really match what's in the record about what happened. And I understand the way we process things sometimes over time changes. But I too believe that you meant to do harm to Miss Caraway. You went there with the intention of doing her severe bodily harm. I've listened to the family of Miss Caraway, and they are really still grieving. I'm not sure they understand what good time is. You do have a mandatory release date, which is February 24th of 2028. No matter what, you'll be getting out that day. I will defer to the victims. My vote today, based on the opposition we heard, is going to be to deny your parole. I do congratulate you on the hard work that you've done, but you've got a release date coming up in the near future. So keep doing what you're doing, mentor others. I think you can help other people. Good luck to you, ma'am. Today you've been denied. Thank you.
Okay, friends, there you go. Denied. So, I have thoughts on this one, and if you have thoughts, feel free to join me and talk about it. But here's the thing that got me. So, she had a whole laundry list. And if you didn't hear the laundry list when we're done here, if you weren't around for it, go back and watch that hearing. And they list off all of the offenses that she committed. And most of them were prior to 2016. And supposedly in 2016 is when she began to find God and to change her life and all of that. However, in 2018, she was found guilty in the facility of a sexual assault. So 2 years after her transformation began, she misbehaved in most definitely, I would say, of the list of things that were read off, that was her That was her biggest offense. Now, I don't remember if it was a sexual assault or a sexual encounter. It was something sexual. So I want to make sure that I'm clear on the record that I could be wrong on that, but it was some sexually related offense in the prison. 2 years after her so-called transformation began. Now, if you've hung around here long enough, you know that I am a Christian, you know that I am God-fearing, you know that I believe in a higher power, and that I hope for people to find the Lord, for people to change, for people to grow. And I am, however, always leery of prison transformations because I think they're often used, as it's been described before, as the Jesus blanket. It's been described on this channel as that, this excuse, this place for people to go and feel sheltered and forgiven and all of that, which is true in a spiritual sense, and it is true in a godly sense, but there is still the matter of the price that you have to pay here on the planet. And she's close to being done with paying that price. She's only 2 years out from release with her good time. So, and somehow, despite all of her violations while she was in there, she still amassed some good time. So she's going to get out in 2 years regardless. But what struck me more than anything in listening to this was I don't understand how so many people, now I guess I've got to defer to them a little bit because they're with her every day, but I don't understand how so many people found so much goodness in this person and are so convinced of her transformation, despite the fact that 2 years into her transformation, she committed what was the worst on her list of prison offenses. It doesn't add up to me. Now, I'm not saying that she hasn't made improvements, and I'm not saying that there's no way she would do okay once she gets out. She might, especially with the support of the Parole Project and them giving her the tools that she would need and the support that she would need. But I'm not sold on it. And it's surprising to me that all of these prison officials and the people who have dealt with her and one of the board members were convinced by it. It doesn't add up to me. I don't understand it. That's the reason why I wanted to show this today. It's the reason why I've been holding it. I was going to show it yesterday, but obviously we had the stream failure, so I didn't do it today. But when I watched this the other afternoon as I was doing other work, I was listening. It's like, how are they so convinced that this woman is like, the bestest thing since sliced bread and the hula hoop? Again, I'm not saying that she hasn't made improvements, and if she has, that's great. But they were talking about what was like her integrity or her honesty, something like that. I don't know. I don't ever think we should be defined by our worst action, because if we're solely defined by our worst action, every single one of us will be eternally damned. It's just facts. Just not all of us have to go to prison for the bad things that we do, but every one of us does things that just, aren't right, So I get that part, but I don't know. Like I said, it was just very unconvincing to me based on the evidence and based on the data that there was a true transformation there. And I'm just befuddled by the number of people who were convinced that there was. But again, they deal with her every day, so maybe they're seeing something we're not. But, if the last bad thing was 2018, it's 2026 now. It's, 7+ years, depending on when it happened in 2018. So, maybe it is real. But I guess I would need more data than what was presented at that hearing, which was part of the surprise to me, that the vote was to parole. I didn't necessarily see that. And the facts didn't all line up either, because people were talking about how good she's been without, any missteps and whatnot. And then they read all of these missteps. Now, maybe when they were speaking about how good she was and the lack of missteps, maybe it was the lack of missteps since 2018. I don't know. But again, I don't get it. And I'm willing to guess you don't get it either, Michael.
I don't get it.
See, I know you.
Dan, I don't, my microphone's all weird today, but I don't understand it. The wrapping yourself in the Jesus blanket, I think, just makes your case even worse, because the Bible, I'm not going to quote the Bible today. This isn't going to be the agnostic teaches you about the Bible.
Ashley, mark down that Michael refused to quote the Bible today.
Will do.
However, well, I won't quote it directly. I will say there are, of all the things in the Bible, punishment and obeying laws is a very common theme throughout. Mm-hmm. And so I think that people need to understand that. I think that if you're going to use the Bible and God and everything as your defense, you should probably understand that I think one of the key elements in there is to accept and obey and adhere to and accept the punishment that you've been given, and to just try and get out of it early because you think that you have found the ways of God and because you think you are suddenly this God-fearing individual. And well, then if you truly are, then as the victim said, then you should sit for your entire punishment, because that is what the state has given you. If that's, that's what you should do. If you've truly accepted God.
Well, I've said it before, Michael, that one of my problems with modern day Christianity and the modern day church is that they're only teaching. Well, I don't want to be absolutist. A vast majority of them are mostly teaching, I'm going to walk it right up to that line, just out of the New Testament. So we're doing the Jesus talk. But you have to look at the text as a whole. For me, the Old Testament teaches us about bad actions and accountability and punishment. The New Testament gives us the path to salvation from all of that. And I think you have to look at both. And I would think you would especially have to look at both for prisoners, for convicted felons. They have to have both of those messages. But the modern day teachings, the way that Christianity is presented now, it's the Jesus blanket. And it's not good enough. You need both.
I definitely agree with that. I think, okay, when you first said that the victims were very emotional and everything like that, I feel for them. I am not saying that they are wrong. They're wrong to feel that way. I think every victim should have a chance to convey their feelings during this. However, I don't think the victim should be the sole. I always believe that the victim should not portray what should happen to that person. That's why you have the board. So that's why I felt that way afterwards. But when you said, Dan, that she committed things in jail, like there were problems when she was in prison, that would justify them keeping her in my opinion. Yes. I don't think, even if it was a few years back or whatever, and such a bad offense like that, I would not put her out on parole, just because of that.
No.
In my opinion.
No, and that's the other thing that was my other point too, Ashley. Good, that was where I was going next was.
Yeah.
Then on top of it, you're talking about how you're God-fearing and you found God and Jesus and all that. And that's great, fantastic. I never think that should, I don't care, even if it is the most sincere thing that's ever been said, I don't think that should shorten your punishment. But also, you have all these jail incidents. You have all these incidents in the prison. And it's not like one or two. I mean, I think most people in prison probably get written up at some point. But I mean, some of them were serious.
Yeah.
Yeah, there was a theft in there, as I recall. I think there was an assault.
There was a sex assault in there.
Yeah,
I
think there was just a vanilla assault too.
Yeah, there was, and there was unauthorized, being in an unauthorized area. There was disobedience, which whatever that means. There was a lot of insubordination kind of stuff that went on. So, and a number of other incidents too. And again, this was a pattern of behavioral problems. We see some people that are in there that don't have a lot of write-ups or haven't had one in 25 years or something. And so I think her behavior there says that she hasn't truly reformed. It says to me that there's still some issues. And, I can't have somebody going out into society that can't even figure it out when everybody's watching you, when you should be on your best behavior. I cannot justify letting somebody out in that situation.
Now, I will say this. I don't remember if it was Wahoo or Charles, but somebody put in the chat when we were watching that if she's going to get out in 2 years anyways, I think the point that was trying to be made was, does it make sense to let her go out to the parole project where at least she has supervision for a couple of years for maybe a softer landing?
That was Charles.
Now, there's a point to be made for that, because when she gets let out, my understanding is there's no supervision. She's just out. There is a point to be made for that. I could see that. We've talked about that, I think, actually before, too. There's been a couple of other times where even the board has suggested letting them out so that they can get the supervision. And maybe, I could see that, I suppose. And maybe, I don't think the victims would be happy with that. And again, as Ashley said, it's not really about what the victims want per se.
Yeah.
But the reason they have them there is for context, is to add context and background. Yeah, they're going to be emotional. Yeah. And as hard as it is for humans to do, we have to divorce ourselves from those emotions. But listen to what they're saying, because the board didn't bring up the prison, the incident reports first. They did. And then the board followed up on that. And I think that added some very important context. And they brought up, not just their emotions and being upset. They brought up the fact that they don't think that she's actually reformed, or at least not totally. And hey, I'm always saying, I think most people, other than, sex assault, I think most other people can be rehabilitated, even murderers or attempted murderers. But I don't think that's what's going on here yet.
Yeah, because you could argue, I suppose, that based on what you're saying, the fact that you could reform an attempted murderer, you could argue that offense in 2018 in prison was a worse offense than the one she's in prison for.
I would, and that's an argument I can make for sure.
Mm-hmm.
Because by your logic, it's not something she can be reformed from.
No. And that's my biggest problem, is that offense, I think, says more about her than any of the other offenses. Because, look, man, I get it. Some people get written up and maybe they just don't want to do something. They're not feeling it. They're in prison.
Yeah.
We all have bad days. It's just, if you have a bad day in prison, it could get you a write-up. But that one in particular is horrible. That's horrendous. So I don't know, Dan. I don't know what to make of that. And then the other thing, of course, drifting over to Hoarder Man. Boy, this is a saga that it's the gift that keeps on giving.
Never ends.
It's been going on technically for 25 years.
Yeah.
And at this point, Hoarder Man is responsible, but I almost don't even blame him anymore. I don't. Look, here's the thing.
Yeah.
Here's the thing.
That's the point.
If bank robbery is a felony, it's a major crime. But if I went in and robbed a bank, and nobody did anything to stop me. Is it really my problem? I mean, am I really the bad person? Or is the fact that we're not putting teeth to a law, is it society's problem? Like at some point, if you don't do something about a problem, you know, it's no longer is about the person committing the act as much as it is about the people that refuse to do anything to stop it. They can scream and yell and say it's bad. But I mean, you said it best. I mean, Woodhaven's not doing anything about it. Judge McNally, who, you know, I love Judge McNally. Whenever, you know, Judge McNally, Judge Boyd, I always go to them. I think they're great. I think Judge McNally is, you know, a fair judge. And I think despite the fact we call him Judge Dad and he does have his grumpy side, I really do think he's compassionate. But I will say this about Judge McNally. I wonder if he doesn't feel bad for the guy because he's old. Like if this was a 32-year-old guy that just couldn't get his crap together, I think Judge McNally'd have no problem dropping the hammer on him. But I think I think he has some soft side for this dude.
There's got to be something there because a couple of hearings back, he actually mentioned that he drove by the guy's house and had a look for himself.
Yes.
So he firsthand knows what's going on there.
And he's put him in jail 5 days twice now.
Oh, was it twice? Okay.
Yeah,
yes.
twice,
Yeah, twice. He's put him in. And he threatened the last time, but he didn't.
Yeah.
And then he's threatening again. And I don't know if he will in March. Maybe he will and maybe he won't. You know, he's done barely anything. He has all of his litany of excuses. Well, I've had the flu since Christmas. And last time it was like, well, I was on a board or something. I was helping people do this for 4 months. Well, that was 2 weeks. And then I had something else. And then it rained. You mean it's been raining for 3 months? Well, you know, it rained off and on. It's Michigan. Yeah, it's going to rain. I mean,
well, in March, you're going to have that cold, wet rain up there. So that's going to shut it down till August.
Or a blizzard. Yeah. I was still digging out of the snow.
Yeah, and his son's too busy to help their dads as well, working over 40 hours a week too.
But Dan, I will say this, and Ashley, I will say this. This, you know, when I guest hosted, we did that long hearing with Judge Middleton. It was another hoarder man. And St. Joe County, they handled that much differently. They just threatened. They said, listen, we've got people that'll come in there and take care of it, but it'll ultimately be at the property owner's expense, and then we'll put a tax lien on the property. Bada bing, bada boom, problem solved. And it was going on for a couple of years or a few years. I know that it had been going on for a while because these things are never instant, but it sure as hell hadn't been going on for 25 years. And so I think that's the way to handle it. I mean, that's ultimately what you have to do. And if this guy, I mean, they have people that are willing to help him.
So, and he's refusing the help because he's not taking it seriously because he doesn't need to. Right. Because everybody's enabling him. I mean, if you see a bratty child in the supermarket, is it really the fault of the child or is it the fault of the parent for not getting that situation under control?
Yes, that's exactly. And that bratty child grows up to be, well, maybe not hoarder man per se, but somebody like that.
No, but even as an adult, you're molded by the actions that are placed upon you. And, you know, that's what we have here. I mean, there's been no real serious action placed upon him. So now we have this behavior. And as far as like the son who's always too busy to help, I think that's an excuse. I think the son probably just said, I'm out.
And that's the thing too. And
he doesn't
I
want to
think,
deal with his dad. Mm-hmm.
Right. And Ashley, I know we've talked about this throughout this saga, all of us in the chat, about the about his mental state, and maybe, you know, hoarders obviously have a mental state, and it's let's be real about it. There's obviously some mental health issue there because they don't want to let go of stuff and they want to keep things, and there's something there. And he just can't. I mean, to me, I'd just say, hey, take a bulldozer, an earth mover, whatever, clear all this crap out and let's get it done. And but he cannot do that for whatever. He's gotten rid of a few things, I guess. It is, Judge McNally said it's a little better, and I guess it is, But it kind of looks like all they've really done is kind of move the junk around.
Well, yeah, because he got rid of a few things and then brought in other stuff because it was
Right.
like wood for cabinets or something like that.
Yeah. So, that's the thing. I think, and I do believe this guy, there's no way he can do it by himself. He is too old and it's too much crap. We've looked at the pictures online over the years. I mean, Dan, you and me, and we could take everybody in our chat and like 10 more people, and I don't think we could all do that.
Right.
If you give us a month.
A month. Yeah, maybe. I mean, maybe. And, again, that assumes that the weather would cooperate, because then there would be weather issues because we'd have to be out there every single day.
We just need that bulldozer. We just need to have somebody to operate that bulldozer and just take it all down.
And then a big truck to drive all this stuff to the dump, the landfill.
Honestly, the play there might just be to turn that particular plot into a landfill. Bulldoze it and fold it in on itself.
Maybe.
Actually,
it's falling down anyway. So
yeah.
Yeah. So, I mean, this is, but this is why we watch TCF. It's stuff like this. It's Horderman. It's the Louisiana Board of Pardons and Paroles. It is, it's all the other cases.
It is fine
too.
viewers like you who call in to chat.
Yes. Yeah, no, this is, you know what, Dan, this has been, it's been fun. I tell you, I will say that this expanded format, this is, turning into quite the fun time. So,
yeah, when the equipment works, it's great.
Well, and then
I
and
do
then
like
there's
it
that.
right afterwards, because if something's, I am one of those ones that if I get worked up over something, the next day I've mellowed out dramatically, and then this way, if you see something, you can react right away. So
TCF React, we could call it.
So react.
That's fair.
Yeah.
Well, I'm not married to the overtime moniker. We can modify if needed. But no, that's the vision of this fourth hour, is to just be able to chat about what we saw and some things that we might not normally be able to chat about, and do something a little bit different from just sitting there and watching court. Having some kind of reaction and discussion is good too.
And one other thing, Dan, we saw and I don't know what it is about McNally's court in particular where we see this stuff, but we saw another pretty interesting traffic case. Interesting
I had that
in a
written
different
down
way.
too.
Yeah. So
a traffic case.
Woodhaven Drift, it was called in the chat.
And this is another case where a guy is fighting a traffic ticket. And for what reason? I mean, he clearly appeared to be in the wrong. I mean, this is one. The other one, that was Judge Middleton that had the other traffic one that we watched that was really kind of crazy. But Judge McNally has these two that sometimes get into full hearings. And we were going down that road today, pun intended, I suppose. And this one, I guess I just don't understand why people would fight something where they clearly know they're in the wrong. But he wants to take it all the way to like a trial. And
does he know he's in the wrong? People will convince themselves of anything, Michael.
I guess so. I mean, I guess you're right. No,
It's his personality, really.
Or maybe it's just like, I don't know. It's that, or maybe they think they can talk themselves, or they can argue it to where they can argue themselves out of it, or maybe the officer won't show up next time, or they have maybe a bunch of agendas. Maybe they really do think they're in the right, and no matter how you show it to them, they will always they are convinced, and in their own head, they really think they're right. I mean, maybe that's what's going on here. I know that's what happened with Judge Middleton. That person, and we kind of were on that, but for a video that the defense actually offered up Judge Middleton was going to probably rule for the defendant and dismiss the case. And so that's, but this time, it was much more clear. The officer was there and the testimony was quite clear. But we see this with these traffic cases, man, too. And listen, I don't drive, so maybe my perspective is different, but I don't know. If I got a ticket for running a light or something, I'd probably just accept it. I mean, I don't know.
Yeah, I mean, there are cases for breaking the law where I might, especially traffic law, where I might fight it. Like, for example, if I was rushing a loved one to the hospital and I came up upon a red light and there was no opposing traffic, I'm running that light.
Right.
And go ahead and ticket me, we'll fight it.
Yes.
But I mean, if you're in the wrong, you're in the wrong. Just accept it and move on.
He shouldn't have. He was Speedy Gonzalez, and he wanted to get around somebody, and that's the end of it. That he went around him when he wasn't supposed to, and that's that. I don't think there's anything to argue there, unfortunately.
Professional driver. What caught me too is when we were first listening to him the first time through, what was it, 3 different segments we had on him? But the first time I was looking at other feeds, so I was just listening. And it wasn't until the second time that I realized this was not a young guy.
Right.
I thought he was a younger guy, and then I looked at him like, oh, you definitely should know better.
Right. I was also like working on stuff here. I was doing, weather and putting stuff together. And so I just listen. A lot of times that's what I'm doing here. There's sometimes I just can't watch because I'm too busy on another screen. But then I did tab over. I'm like, wait a minute, this dude, this is no spring chicken. So it definitely changed my perspective on that. And he was just stubborn and steadfast, man. And I was a little shocked by that. I really was.
It reminds me of people in Ford trucks. I don't know. I have this person.
That's very specific.
Yes.
It is specific, but it's like an ego thing, in my opinion, because they always think they are ruler of the road and they act like it. And I feel like this guy is one of those guys, even though he wasn't driving a truck, but he kind of remind me of somebody that would drive a truck and just trying, they think they can do whatever they want to do.
He did say he was a professional driver, Ashley.
Yeah, exactly.
Yeah.
Yes.
With a fast and furious conversion on a Ford Focus.
He reminds me of people that drive an 85 Firebird, but red. Like
Pontiac Fiero.
Yeah.
Those sports cars, man.
Yes. A Cutlass Supreme.
Right.
My goodness.
Mama Jones, like, he wasn't driving a truck, thankfully. I'm thankful, too. He might have run me over.
Mm-hmm.
Oh, anyways.
You never know what you're going to get on TCF.
That's why we do this.
Yes.
We don't know what we're going to get tonight either, guys. Sidebar, 8 p.m. Eastern, 5 Pacific. You'll both be there.
Yes.
The chat is in control. May God have mercy on us.
Oh, dear Lord, it's the demon bird. Yeah. Yeah.
I'll be very
We're in for it. So that'll be tonight, 8 p.m. East, 5 p.m. Pacific. Join us right here on TCF for Sidebar.
Thank you for the promo, Michael.
Of course.
All right, I'll see you guys tonight.
See you tonight, Daniel.
See.
All right, friends, that is it for this episode of TCF and TCF Overtime. I hope you all had fun today. I know I did. Again, we'll be back tonight for Sidebar, 8 p.m. East, 5 p.m. Pacific, and tomorrow morning for this show, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour early for channel members. And again, if you're a channel member, you can hop on stage during the 4th hour, just like Ashley and Michael did. So give that a try at some point. Go have yourselves a great Thursday. Again, I hope to see you tonight. And if not, most certainly tomorrow. Take care. God bless.